rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division are here. In the attendance, you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time you actually need. More than 8 hours of argument time that has been requested, and we're not going to be able to accommodate that, of course. Remember that if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have a chance to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People v. Marcellus Hill. Submitted. Steinman v. Steinman. Submitted. B. Kirk is submitted. JAK Advisors v. Bauer. I'll give you 4 and 1 and 3. Greenman v. Miller. Five and 2 and 5. Mustafa v. City of New York. I'm sorry if I'm mispronouncing the name. Okay, 5 and 2 and 4 and 4 and 2. Did you want 4, just to go with the other? Okay, we'll give you 4. People v. Anthony Vega. Absolutely. We'll hear you for 2 minutes. People v. Jefferson Jasmine. Submitted. Continuum Energy v. Iron Oak. 5 and 2 and 5. Tejada v. 57 and 6 ground. Five and 2 and 5 and 2 and 3. R. Tristan. Submitted. Yolanda Management v. Microalgo. What was it? I'm sorry, I missed the word. 3 and 2 and 4. Thank you. People v. Rivera. Submitted. Prof 213-S3 Legal v. West Fork. Look, you don't have an opponent. You'd like to be heard briefly? Yes. All right, I'll give you 2 minutes. On Kennedy v. Roman Catholic Archdiocese, Justice Gonzalez is recused. 5 and 2 and 5. People v. De Los Santos. Both 5 and 2 and 5. Watson v. Intercounty Paving. With 5 and 2 and 4 and 4. People v. Kitchens. You're for the appellant? Okay. Very well. Submitted. Thank you. Arias v. Brooks Holding.
Good afternoon, Appellant, requesting 5 and 2, please.
We'll see. 5 and 2 and 4 and 2. 4 and 2. Okay. Pennymac Loan Services v. Valdez. Would you like to be heard, counsel? Just to be equal, I'll give you 2. If we have questions, we can go beyond that time. Thank you. Okay, first case up is JAK Advisors v. Bauer. Oh, I'm sorry. One last case is submitted. That's SG and Infant v. New York City Health and Hospitals. That is submitted.
May it please the court, Scott Watnick for appellant. This is an appeal that arises from the trial court's grant of a CPLR 3211 dismissal motion. First and foremost, this appeal raises the question of whether WhatsApp messages, 30 non-consecutive pages of WhatsApp messages that are rampantly missing text, can constitute undeniable documentary evidence under CPLR 3211A1.
Counsel, if we read the text messages from page 163 in the record through 167 in the record, don't we see there an agreement between the parties to settle this matter for $826,000? And the defendant actually sending that money over to the plaintiff, who provides his bank account information, routing number, and then there's a screen showing that the transfer was made. What are we to make of that?
Well, Your Honor, firstly, there is no documentary evidence that is undeniable of how much money was sent. If we look at record page 167, there is a...
Counsel, was any money ever sent back by your plaintiff to the defendant?
That's
He
outside
retained what he was sent, correct?
to my knowledge, some money was sent, Your Honor, and that's what the record
That's not my
reflects.
question. Your client retained the money that he was sent, correct?
I believe that is correct, Your Honor. But, Your Honor, these are
You
funds...
believe that? I mean, isn't that an uncontested fact, counsel?
He was sent money, he retained those funds, Your Honor, but not the complete amount that we allege is owed. And
He retained those funds for nearly 3 years before he sued, correct?
that is correct, Your Honor.
Please continue.
Your Honor, missing text, and we submit to the court that approximately 50% of the 30 pages of the WhatsApp messages are in fact missing text. And as an example, Your Honors, if we look at 167 of the record...
And the missing texts, those were provided to the court below?
They were not, Your Honor.
So how can we deal with that?
Your Honor, I submit to the court that the court erred in treating the WhatsApp messages as undeniable documentary evidence.
Counsel, have we held in prior occasions that electronic messaging or like emails or text messages can constitute some sort of proof where there's a sense from a certain number? Has that been our case law?
Your Honors, electronic messages can constitute documentary evidence under A1, but we're unaware of any authority where the electronic messages are missing text, the contents of which are unknown. But if those missing text messages weren't provided to the court, it's just, you're just saying that's just your allegation, that there's things that are missing. How would anyone know what is missing? That's the exact point, Your Honor, and it's not an allegation. We can demonstrate...
Counsel, didn't you have to demonstrate that below?
Your Honor, we argued below that that the WhatsApp messages are non-sequential and thus missing text.
Yes, but you didn't have an alternative, a fallback argument, as in, and here they are, just in case you rule against me?
Your Honor, my understanding is that the WhatsApp messages are irretrievable in their original undeniable form. And that's why the proponent of the documentary evidence submitted them with,
What is an undeniable form? That I have never.
as they originally were sent and received, Your Honor.
You're saying that there can be no record of WhatsApp messages?
My understanding, Your Honor, is that in this situation, in their original form as they were sent and received, there is no record and no way to retrieve them as they were originally sent and received. That
So
is my understanding.
these messages which are in the record, are you saying that they were not the way in the form that they were originally received?
That is correct, Your Honor. They were not presented by.
They were put together by your opponent?
That is correct, Your Honor.
That's what your allegation.
Yes, Your
And
Honor.
what do you base that on?
Because we can just simply look
Do you
at.
have an expert's affidavit to say that this was somehow concocted by your adversary?
No, Your Honor, but if we simply look at the messages themselves, we can see, for example, at the bottom of R167, there is a screenshot of a purported wire transfer. There is a response to that at the bottom of R167, but we can't see what it says. And there's another response at the top of.
Does your client say that the wire transfer was never made? I thought he retained the money that came through that wire transfer.
Your Honor, we received funds to which we claim we were already entitled to. They were partnership funds. And Your Honor,
Is that a distinction without a difference?
Your Honor, because they were funds which we allege we were already entitled to, as our papers reflect, they can't constitute valid consideration. There's also no essential terms in these WhatsApp messages. And again, they're incomplete. And because they are incomplete, the content, it cannot be said to be undeniable within the meaning of A1.
Thank you, counsel. You have time to rebuttal.
Good afternoon. Just a couple of short
Counsel,
comments.
Would you make your full appearance, please, so that we know who
Daniel,
you represent?
I'm sorry, Daniel Steinberg for the defendant respondent.
So counsel, normally on an A1 motion, right, when we're going to say something that is provided utterly refutes any claim that the plaintiff may have, you know, it's like an account stated case, it's, you know, just receipts and paper documents. In this particular case, why aren't these WhatsApp messages subject to any kind of interpretation as to whether or not there was an actual offer and acceptance, or were they still in the middle of negotiations or something like that?
If there were uncertainties as to what the WhatsApp messages mean, certainly they wouldn't be sufficient. But here, when you read the messages, they were going back and forth and negotiating. They came to a determination as to an amount of money that would resolve their dispute, and the money was paid. It's a classic accord and satisfaction.
What should we make of your adversary's position that the text messages are incomplete and somehow maybe out of order or concocted?
So the one part or piece in the record is an affidavit from the plaintiff where he acknowledges that the messages were exchanged. There's no claim below that the messages weren't complete. The only thing that the appellant is latching onto is my client's acknowledgement that in downloading these messages, there's a certain duplication that occurs, and it's possible that a sentence may have been cut off somewhere. But there's nothing in this record at all that says that these messages are not complete, that there's anything missing. And there's nothing in this record below that explains how anything was different. The monies, it was negotiated, it was agreed to, and it was paid.
So,
That's the import of the message.
Counsel, when I look at some of the messages, plaintiff says, "Let me consider it. I appreciate your position. The numbers feel off, but I trust you more than my own memory." And then later on says, "But I will agree to your split of profits, and I would like to put this to bed quickly so we can all move on with a handshake." At any point in time, is there an affidavit or is there anything that shows that there was a rejection of the offer to settle?
No, there's nothing. The offer to settle was accepted. The wire instructions were provided by the plaintiff as to where he wanted the money sent. He actually changed his instructions at one point to a different account, and then the wire was sent.
Counsel says that the money that was sent was money that was owed and doesn't count.
So a dispute had arisen because one of the two, the defendant, was succeeding. I'm sorry?
Can you talk louder for
I'm
me?
sorry, sure.
Thank
One of the parties was successful in selling and earning money. So the partnership had become completely lopsided. The plaintiff was completely unsuccessful in not generating any revenue. So by the time that this happened, they were at odds with each other. They were struggling to find a way to resolve their dispute. And this is what they did. Instead of splitting 50-50, they split 1/3, 2/3. That's basically what it was. In order to make it happen, my client sweetened the deal by adding $150,000 on top of it. But that was the arrangement that was made, and it was, as your honors have recognized, 3 years went by without objection after having accepted the money. And this court has held many, many times that is a ratification and should be the end of the story. Thank you so much.
Thank you, counsel.
Your Honor, it can only, the trial court found that an accord and satisfaction, and there can only be a ratification of the accord and satisfaction if there was one in the first place. And again, the only evidence of money paid here is at R167. It's a screenshot of a wire confirmation. It doesn't say the amount paid. It doesn't even say who received it.
Are you contesting that? Are you contesting that money was paid? Are you contesting the amount that was alleged to have been paid?
Your Honor, there's no record evidence as to the amount that was paid. This is a 32.
That's answering another question, not the one that I asked. Are you contesting it?
Your Honor, I don't know how much they are claiming. It's not in the record as to how much money was paid. We've alleged that we were entitled to 50% of the partnership proceeds. They're claiming they paid 33% in these WhatsApp messages that are incomplete.
Right, but the issue then is, did you, in the hopes of settlement, to put it to bed, as my colleague read the text message, settle for 33% and forego that 50%? Isn't that the issue?
Your Honor,
And so then if that's the issue, and you're saying, well, they only paid 33%, but here is where we did not agree to that. Isn't that what's missing?
Yes, Your Honor, we did not agree to that. These WhatsApp messages do not reflect an offer or acceptance. We have vague and ambiguous language which fails the undeniability test of A1. At record 164, respondent writes, I'm willing to go that extra mile if you agree to now finish this. At record 165, appellant responds, if that is the case, I just want to move on. This is a conditional offer at best, a conditional acceptance at best. I don't know what finish this means. We don't know what, if that is the case.
So if we begin with the offer, I'm willing to pay you $826,000 now if you agree to put this to bed, right? To settle it. This is a one-time offer today. Basically, that's what it says. It says, I can't keep going back and forth. And the emotional roller coaster it puts me through. I will send you $826,000 today if you agree. Then your client responds, it doesn't make me happy, but I'll take it. And then send me your account number. Your client sends the account number. And then here's the screenshot that says the money has been sent. What are we to make of that?
With your
That you're talking about some other monies or the $826,000?
But Your Honor, there is no relinquishment in these WhatsApp messages of any claims. There's no discussion of any claims. There's no release of any claims. There are two respondents here. One is in a limited liability company. Is that company released from any of the claims that were brought in this case? There's no way to discern this. There could be text in the WhatsApp messages that is missing. He doesn't deny that it's missing.
Anything could be in texts that are missing. They haven't been shown to anybody, so they're a secret.
Because our understanding is they're irretrievable in the form that they were sent.
So
and
then
received.
they don't exist for our purposes, right?
But it can't be said that this is not the embodiment of all of the communications between the two parties. In Osang v. Netterhofer, the very same trial judge addressed a similar issue where the WhatsApp messages did not embody the full conversation between the two parties. That's the same situation here because 50% of the 30 pages contain lines and texts that were sent and received that are missing.
Thank you, counsel. You make that point in your briefs. Thank you both.
Thank you.
Greenman v. Miller.
Good afternoon, Your Honor. Paul Allo, Contract and Allo for Defendant Appellate, Mr. Miller. I'd like to start today with the 392 Columbus piece. This was the entity that originally Larry Miller and Charles invested in a piece of real estate at 392 Columbus. The split under that was supposed to be, after initial return, 2/3, 1/3.
Then that was amended, correct?
Well, so
To 50-50.
we don't agree that it was amended, and it was, the court found, as a matter of summary judgment, it was amended, and that's one of the things that we're contesting here.
But if we look at the record, page 5465, you have a certificate there that says that the operating agreement of 392 Columbus Avenue LLC has been amended as attached.
Correct. So that entity, Mr. Greenman, who was the attorney and the business partner here, used that entity for a wholly unrelated investment in Brazil for his daughter. And we agree, by the way, that that investment was a 50-50 investment. What we don't agree with, and we don't think the record supports as a matter of law, is that the 392 Columbus, the real estate, which had been bought 90% with Mr. Miller's money and was supposed to be 2/3, and by the time this so-called amendment was made, those monies had already been received and had been distributed, but not in accordance with the agreement, which Mr. Miller didn't know about.
But the writing that we have says that the agreement has been amended as attached, right?
Well,
And the attached agreement,
It's basically what the agreement we have basically has it's got a new Schedule A.
yes.
And it's certified so that it can be used in Brazil. Okay, the agreement, if you read the agreement, even the
But does
amended,
this
even the amended
agreement say that? Does this agreement say that?
agreement,
Counsel, don't interrupt.
Does this agreement say that?
this agreement does not, it only has a swapped Schedule A. That's all it has. I agree with you that it could be ambiguous, but remember, Mr. Greenman, and I struggle with this because we have all these things where people sign things and they're bound by it. Remember, Mr. Greenman was his attorney too.
But this is what the court has.
That's
It has a written agreement that says it's been amended, and this is the way that, according to Schedule A, that any funds are going to be distributed.
Well, the question is, under these facts, under the undisputed facts, whether or not what was being amended was the distribution from the Columbus sale, which was a separate, complete, at the time of this amendment, was already finished. So that's our point. And there's no evidence in this record where Mr. Greenman said, hey, you know what?
Was there any language used, amended as of a certain date?
Well, the first page, no, the amendment doesn't say that. The first page has an as-of date. But the amendment, I don't think, says as of. So I think if one were to read this, especially a layperson being handed a document by his lawyer, you would not assume that what you were doing was this other piece.
Handed it by his lawyer?
What?
So had a lawyer?
His lawyer was
Had a
Charles
lawyer?
Greenman.
Okay.
Only lawyer he ever had was Charles Greenman. So so our position is that the court erred in granting summary judgment, and that when the monies were evened out, because 392 was then used for two other investments, it was evened out, that was entirely correct because it was 2/3, 1/3 for that investment which had not been properly allocated. So it's the allocations should have been 2/3, 1/3 for the Columbus and 50-50 for the other two investments. And this is not good lawyering. I would agree with that. It's not good lawyering, but the lawyer here was also the participant. I mean, the record is clear, and everybody agrees that Charles was like Larry's brother. He was the only lawyer he ever had. And I think one of the things here is effectively, if you view their view of it, then Larry was essentially making a gift to Charles, because it was always agreed that he put up 90% of the money. So why was he making this gift? Where was the evidence that he said, hey, somebody else should review this? None of that. So we think that the principal point I want to make here is we think that was an error. At the very least, it creates a triable issue of fact of what that means. I know my time is, well, my time's
You
up.
do
I
have
forgot
time on rebuttal, too.
What?
You have time on rebuttal.
Okay.
Charles Wallman for respondent. I'll begin with 392 Columbus, as we talked about. Case after case in New York states that when an agreement stated as of a certain date, it applies as of that date, even retroactively. That's what the words conclusively mean. They cite no authority to the contrary. The case law is also clear that you're bound by the terms that you signed, even if you claim you didn't read it, you didn't know what it said.
Also, it's the case that Mr. Greenman and Mr. Miller had a long-standing, a very informal partnership that was embodied in different entities, and that they often sort of did horse trading, it seemed like to me. It was not a very well-papered partnership, but they trusted each other, is what seems to come out of Justice Cohen's decision.
I would agree with that. That was the finding at trial. I'm not aware of any authority that because the parties had to trust each other, that therefore the standard case law that a party's bound by what's in the agreement wouldn't apply. I don't believe they cite any in their appellate papers.
No, I was just talking more about your opponent's point of view that it was a windfall for Mr. Greenman, and instead it might not have been a windfall, might have been payment for something else, some other transaction.
Well, I'll start pointing out that I think it's misleading that in the presentation that, yes, he gave 90% of the contribution, but he was paid an 8% preferred return on his 90% contribution. He was paid that entire 8% return and his 90% before the agreement saw $1 under the 50-50 split. So yes, it was asymmetric in terms of the contributions, but he benefited from that in the payout. So I don't know if there was, calling it a gift or that it's a windfall. I don't think that fits the facts, undisputed facts of the case.
You're Mr. Charles Greenman?
I'm sorry?
Are you Charles Greenman?
I'm not.
You're not, okay. I thought I heard you say Charles Greenman for the respondent.
Charles Wallman, it's close.
Okay. All right.
Please continue, counsel.
Okay. Staying on 392 Columbus, I just point out that even if the court sees the need to look to the extrinsic evidence, the undisputed facts confirm that at the time, the parties understood the deal was 50-50. They admit on page 15 of their opening brief that at the time of the February 2012 distributions, that they were divided 50-50. Everyone understood, including Miller, understood that the deal was 50-50, even on the property. And then within weeks, sorry.
Counsel for the appellant says that his client was duped, that Mr. Greenman was playing, right, was playing two roles, business partner, but his trusted lawyer. And he kind of insinuates that there was a conflict of interest there.
Right. I'll first point out there was no evidence put forward in summary judgment about trying to find that he was his lawyer. That wasn't an issue.
That's new, isn't it?
Yes. So to me, but putting that aside, the evidence in the record shows that Mr. Miller understood the deal to be 50-50 on the property. That at the time, they admit on the brief, at the time of the distribution, he understood that. And a few months later from that distribution, even after the amendment, they're still describing the deal on the property as 50-50.
Then after the death of Mr. Greenman, the widow gets very little of the, by way of distributions, right?
Yes, a nominal amount. Mr. Miller takes,
Like 1 million and change versus 7,000.
that's one and, I think 1.5, yes, something like that. Remaining time, just turning briefly to the issues of, remaining issues. The issue of the commingling of expenses, the litigation expenses. Mr. Miller admits that he knowingly used Millman funds to pay for expenses unrelated to Miller, such as the 392 Columbus claims. There's no provision in the agreement that even plausibly would allow Miller to spend Millman funds on non-Millman expenses. Mr. Miller's never reimbursed Millman for those expenses, never made an effort to allocate the portion of his improper expenses. On this, the case law is clear. When a fiduciary commingles expenses, as he did here, he bears the burden to sort out his commingling. Just like in any situation of a fiduciary self-dealing, he bears the burden to establish the fairness of his transaction. And
And what about the argument that he was simply winding down whatever businesses that they had together?
Millman LLC, he was just winding down that business and the others.
we're turning back to the loan appropriation issue? Or on the, because this is, I'm just addressing
Yeah,
the,
yes, and the breach of fiduciary duty arising therefrom.
Yep.
Okay.
So turning to loan misappropriation. So Mr. Miller had no right to encourage Millman's borrowers to pay off their loans early. He admitted at trial that's what he did. It was against his fiduciary duties to encourage Millman's borrowers to pay off their loans early, costing Millman $1.7 million in lost interest, while at the same time he had competing entities and was offering competing loans to thus same Millman borrowers. Thus, that's a clear breach of fiduciary duty, and there was ample evidence for the court to find in the trial record to find that that's what Miller did.
Thank you very much, Counsel.
I'm going to try to be quick. First of all, the record is clear that Mr. Charles was Larry's lawyer. That was never disputed. It is in the record, both on summary judgment and at trial. So that's not true that that's new, and there is no evidence of that Mr. Miller understood that he was reallocating or making essentially a gift to an individual who had been his friend and his lawyer. In terms of the fees, I think the answer here is the court simply took all the fees. Mr. Miller was entitled to indemnification for the portions he was successful. We calculate that he was successful in more than 50% of these claims.
Can you address the issue of fiduciary duty? Mr. Miller set up a competing entity, a competing lending entity, Corinthian,
Yes.
and then, according to the allegations, diverted the business of Millman, the jointly held
So there's
company, to himself.
There's a couple of responses to that. First of all, there's no evidence that he diverted the loans. The evidence is that loans were
Not he converted, he encouraged the lenders.
But if you read the
borrowers,
record carefully, that's just not true. He certainly he wanted to wind down the thing. And if you read this record,
But the loans that were outstanding under Millman, they then went under the company for which he.
no, they were different loans. They were literally different loans.
Because he encouraged them to pay them off and then
Well,
open up
With the
new
money
loans
that
with
he
himself.
lent them.
So the evidence here, and it was actually in summary judgment, but the evidence here is that the borrowers, basically David Burley and Mr. Zworski, they wanted to lend the money. There's no evidence that he encouraged people to prepay the loan. So did he want these loans paid off? Yes. And one of the things I think it's important to understand about the loan business is, one, all this was Larry's money. He was lending Larry's money, splitting the money. Two, the agreement, the Millman agreement, which Charles Greenman wrote, actually prohibited members from lending money. So it was not the business. It wasn't allowed under the agreement. And in fact, the agreement allowed both people to compete. In fact, they did. Both of them had relationships with Mr. Miller, with Mr. Burley and Mrs. Zworski, and they made all kinds of loans. The Greenmans made more loans than Mr. Miller. So it's unfair to say, obviously there are situations, I'm in a law firm, I can't go out and have a side law firm because I give 100%. That was not the case here. They were certain specific loans that Larry decided, and he is not questioning this, that he'll put up the money, Charles will service them, and they will split the profit at his lower rate. And He shut this down because he said to Jane, Jane, if things go bad, we know that loans went bad in the
Wanted a
real estate.
guarantee, no, I know you talk
He
about
said, yeah,
that.
he said, listen, I'm not taking all the loss on the backside. You need to at least guarantee. And that's when he said, this doesn't make any sense because I'm doing 100% of the work. I'm taking 100% of the risk.
Thank you, counsel.
Thank you very
both.
much.
Mustafa v. City of New York. Please.
Glenn Dolan with the Office of Morgan Levine Dolan for the plaintiff appellant. May it please the court, plaintiff appeals from a judgment dismissing all claims against the City of New York and from an order denying plaintiff's motion for summary judgment pursuant to sections 240 subsection 1 and 241 subsection 6 of the labor law, beginning with the city's status as an owner under the labor law. It is undisputed the city owned the roadway and the sidewalk where the excavation work was done in this action.
Whose burden was it to prove up the existence or absence of a permit?
That would be the City of New York's burden on its motion to dismiss all claims against it.
Was that done?
Withdrawn?
Was it shown definitively that there was no permit or that there was a permit?
It was not shown definitively that there was no permit. There was evidence submitted that the work was done pursuant to a permit. At page 911 through 914 of the record on appeal, the O'Grady proposal requires that the work be done pursuant to a permit and that O'Grady, that's my client's employer, obtain those permits as step one prior to beginning the work.
To the extent that a permit would have been supplied, would that have established a sufficient nexus between the city and the plaintiff?
Okay, first, it's plaintiff's contention that there is no nexus required. With regard to the City of New York, this is not a public services case. Plaintiff was not a public services plaintiff. And so an owner is an owner is an owner under the labor law. They're fee owner of the roadway and the sidewalk. However, to the extent that this court feels that it is the plaintiff's burden on its motion for summary judgment to establish that there was a nexus between the city and the plaintiff's work, plaintiff refers to the Morton versus State case at 15 New York 3rd 50, a 2010 decision, that's 5 years after the Albanese decision. In that case, the state did not issue a permit for excavation work done on a state highway.
We're familiar with that case. Do you want to turn to the merits of 240?
Sure, Your Honor. So there's two scenarios presented on Labor Law Section 240. One, that a 400-pound cast iron pipe rolled from a pile at the edge of an approximately 5 to 6.
Yeah, but do we have competent evidence of that narrative? His colleague, Mr. Halucci, who I'm sure I'm mispronouncing his name, he didn't say, I saw what happened. He recounted what happened, but we don't know the source for his statements.
Well, we know the source is Zakir Halucci, who said, I was his coworker. I was on this job.
No, but this missing those words, those magic words, I watched the accident happen, or I saw it happen, or how do I come to this knowledge that it was the rolling of the pipe into the ditch that caused him to be hit by the pipe?
I think he established how he came to the knowledge by saying he was there on the date and time that the incident took place.
Okay, say we disagree with you. What else you got? What's the other narrative?
The other narrative is that the coworkers accidentally dropped the 400-pound cast iron pipe into the excavation and that it struck the plaintiff. Under either scenario,
That's what the plaintiff said. It is EBT, right?
He speculated to that, Your Honor. Yes, he does concede he was crouched down at the bottom of the excavation, 5 to 6 feet below, looking through a tunnel that was at the bottom of the excavation. But he speculated that his coworkers dropped the 400-pound. As Your Honor points out, there's two scenarios, but under either scenario, the plaintiff is entitled to summary judgment under 240. Under the first scenario, no chocks were provided to secure the pipe at the edge of the excavation, and no overhead protection was provided above the plaintiff. And under the second scenario, no hoist was provided to the coworkers to lower the pipe or to move the pipe from place to place. Therefore, there's a violation of Section 240 of the labor law under either scenario. On section 241.6, also specifically Industrial Code 23-2.1A2, it holds that material and equipment shall not be placed or stored so close to the edge of a floor, platform, or scaffold as to endanger any person beneath such edge. So under that scenario, scenario number one, provided for in the affidavit of the coworker, this 400-pound cast iron pipe was put in a pile at the edge of the excavation and it rolled into the excavation.
So you contend, I mean, obviously, it wasn't being stored there. So you say placed embodies the placement of equipment that's necessary for the job being done, and so that's what would capture it?
Yes, Your Honor, and it was stored only to the extent that they weren't in the process of installing that pipe at the time of the accident. Plaintiff still digging the excavation is at the bottom of the excavation, looking through this tunnel that's toward the bottom of the excavation. The tunnel is where the pipe is going to be inserted and goes to the adjacent property. So they weren't actually in the process of installing the pipe at that time. It is stored or placed temporarily at the edge until they get to that phase of the work.
Thank you. You have time to rebuttal.
Thank you, Your Honor.
Thank you, Your Honors. Kyle Dorn for the City of New York, respondent in the City of New York. Your Honors, I submit that the motion court correctly found that the City of New York is not a proper labor law defendant here, as it was not.
Counsel, sit a little closer to the microphone or pull it
I'm
towards you.
sorry, Your Honor.
No problem.
I submit that the motion court correctly found that the City of New York was not a proper labor law defendant here, as it was not a property owner involved in the construction work. It did not exercise.
How do we know that? There's no indication as to whether a permit was issued or not issued, and according to Morton, the issuance of a permit will create the nexus.
Thank you, Your Honor. I actually think that Morton is distinguishable from here. Morton dealt with a specific type of permit, a DOT permit issued for opening a highway and a street access, and the specific requirements of that permit. And in Morton, they dealt with, in their dicta, they discussed how that requirement, the specific requirements of that DOT permit could create an additional.
Yes, but is there any authority that says that permits are distinguishable one from the other per agency or per type of work?
I'm sorry, is there any?
Is there any case law that says permits are different one from the other as far as the nexus that's referenced in Morton?
Well, no, Your Honor, but I rely on the.
So this is
my interpretation.
opinion.
And my suggestion to the court that Morton should be limited to in that dicta was intentionally by the Court of Appeals. They went into depth about the requirements of that DOT permit.
Well, this court more recently in Powell has dealt with these permit issues, right? And the same issue presents itself, whether or not there's a nexus or whether or not the city has established, either by showing permit or no permit, the particular nexus necessary.
My understanding from the Powell decision was it dealt with that was the franchise agreement with the Verizon contractor, unless I'm misremembering the case. But my understanding also is in the Albanese case, I would point to, and the only way to rectify Albanese with Morton is to find that Morton was speaking as to that specific DOT permit, whereas in Albanese,
The Albanese case predates the Morton case, though, right? So the Court of Appeals looked at this permit issue after Albanese.
yes, but in
And they've come up with this nexus language that we're supposed to be looking at.
Well, the nexus language comes from the Guriev case, where the Court of Appeals discussed property owners such as condominiums and cooperatives, how they can have a nexus to ownership or lack a nexus to the work.
Well, I'm looking at the Powell case as well, which, as you know, was authored by Justice Mendez, and there's no distinction here as to permits, one type of permit as opposed to another type of permit.
That may be the case, Your Honor, but my suggestion is that the Morton. I don't have the case in front of me, and I apologize, Your Honor. But my suggestion is the Morton ruling, which is binding, should be limited to the DOT type permit, not the typical work permit issued for an abutting property owner just doing work. And I would suggest, Your Honors, that expanding the labor law liability of cities and municipalities to every time they issue a permit for
The
work.
permits give the city the right to inspect, right, and the right to shut down an excavation or an installation or a construction, right? And that's awesome power, isn't it?
They can, but that's not necessarily every permit could be different. A permit could be. could
And
have
here in
different
this
requirements.
case, where pipes were being laid, this would, allow the city to come and inspect
It
and
may-
shut it down if needed be.
If a
need be.
permit was issued, it may have, Your Honor, but.
So the burden was on you to say, there is no permit here, we didn't have anything to do with this, no permit was needed, or a permit was needed and these people did not get one, or yes, we did issue a permit. That power, that knowledge was in the city's hands.
Well, I'd first suggest that the permits are available publicly. These aren't controlled specifically by the city, such as a franchise agreement. But I would also, and I see that my time has
You
expired.
can finish, you have 30 seconds.
Thank you, Your Honor. I would suggest that just because a permit is issued, and that is the Albanese case.
You're beating a dead horse, aren't you? I mean, I love horses, so I should not say this.
Understood, Your Honor. I would suggest that we would need to see the specific permit if a permit was issued, but because a permit, there's no evidence of a permit being issued here other than vague references in a proposal, that there is no evidence to support that a permit was issued on this record.
Thank you, Counsel.
Thank you, Your Honors.
May it please the court, honorable justices, Dennis Monaco for the owner of the property, Themel Holdings. I basically would say that the court was right in the beginning when you started to talk about the contradictions and the plaintiff meeting their burden. It's our position that the plaintiff's testimony throughout as to every salient issue was actually contradictory, whether it be with respect to the size of the trench, the depth of the trench. It was 3 feet, it was 5 feet, it was 6 feet as cited throughout the.
Was it clear that, his testimony, wasn't it clear that the pipe fell on him while he was inside the trench?
Well, it becomes questionable when you look at the size of the trench, even in the photographs, which I think.
What's questionable?
How deep he would have been in the trench when you look at the photographs of how deep the trench actually was.
It depends on whether he's crouching or standing. So he says he's crouching.
And
He's got his back turned, and then the next thing, there's a pipe striking him.
Well, he says that the pipe, at one point he says in the testimony, the pipe is being handed to him. Another point he says he surmises that maybe it rolled on him. And that's cited at page 405 in the record.
But whether it rolled or someone was holding it and dropped it on him, he was struck by a pipe.
Potentially, but he cannot say what the cause was or how big the pipe was even.
Are you saying that he wasn't hit by a pipe?
To me, it's questionable. I mean, if you looked at the depth of the trench.
Questionable according to whom?
So if you look at the statutory hearing, he has the trench at 3 feet, which comes up to about your hip. If you look at the photos, it looks like it might even be lower. So I mean, there's still
You're going
questions
to
to
the,
be
no,
resolved.
no, no. You're going to the height. My question was, are you saying that no pipe fell on this man?
That's not what the evidence says one way or the other. I mean, it's his testimony that he was hit with a pipe. There's nothing that says that he wasn't.
Okay.
Yeah,
It's
I will,
unrebutted.
obviously, yes.
That's unrebutted, right?
That's
So you're disputing the depth of the what you would call it of the trench?
it's also not necessarily, well, the depth of the trench would show how crouched he would be in at all, if crouched at all. If you look
And
at
you're
the
saying
photographs.
that the whole issue of elevation and gravity, those really are an issue here?
What do you mean in terms of elevation?
No. Do not ask me questions. I ask you.
In terms of the hole itself and whether or not the pipe fell in the hole, it appears that that's the case. But it's the size of the pipe that's different, the depth of the hole that's different, the mechanism of the accident, none of it's explained. It's just the accident.
Doesn't
occurred,
that go to
pipe
damages?
rolled off.
Doesn't that go to damages as far as whether he was crushed by a 400-pound pipe or whether he was seriously injured by a 50-pound pipe?
It also goes to damages, but it also goes to the respect, if you look at his medical records, he wasn't hit in the head or neck.
But we're talking about liability here.
That is the liability. He mentions a small pipe in his medical records, not a 40-foot-pound, 400-foot pipe.
Are the medical records sworn? Are they competent evidence? No.
They were submitted by the plaintiff on the motion, so.
So you're holding against the plaintiff?
Well, I
Okay.
would say it's a statement against his interests, obviously. And
What were the injuries that he sustained? What did he allege were the injuries?
it's neck and back injuries.
Didn't he sustain a fractured vertebra?
I believe so, yes.
Okay, so how would that occur if he wasn't hit by some heavy force?
Right. No, I'm not saying that he wasn't hit necessarily, like I said.
Well, that's exactly what
know
we've been
whether-
asking.
Yeah, we're going in circles here.
Well, the point is that there's so many different versions of the accident
I don't
provided by the
think so.
plaintiff himself.
I think it's your version and then the other, the version that is consistent from the record.
Well, I'm reading, if you read through the record and the pages that are cited, you know, the plaintiff, he's employed by a plumber, he's, you know, he's working in a trench. At his deposition, he's testifying the trench is 6 feet in depth, which is record 394. In his 50H hearing, he's testifying at page 30 that it's 3 feet in depth. You know, the depth of the hole changes, the width of the pipe, the heaviness of the pipe, it all keeps changing throughout, which makes it speculative.
But does it,
I agree that
does
an
it change that the pipe hit me in the back? It
No.
struck me in the back. That doesn't change.
No, again,
There we go.
that part does not. But it's speculative as to what caused it, how big the pipe was, and other issues.
Thank you, counsel.
Good afternoon. My name is C. Briggs Johnson for the respondent of Village Cleaning. So, even if, like we said, the version of the accident is unrebutted that the pipe rolled onto his back, we still have issues
Rolled
of
onto his back
or-
or fell on his back?
rolled onto him from the trench where it was dropped. There's still an issue of fact regarding whether or not the elevation-related risk was de minimis, because as co-counsel just said, plaintiff submitted medical records in a related proceeding, thereby adopting its contents as accurate,
And
right?
I don't know, so it said it was a small pipe.
Right.
That doesn't speak to the weight of the pipe.
No,
That
but
doesn't have anything to do with the fact that it rolled off, was pushed off, was handed to him and fell off and fell on him. It's a small pipe.
yeah, but if it's a small pipe, there you can there's an inference that it's probably not 400 pounds, right? Because he's
I
testifying at
don't
his
know, I don't deal with pipes. I
Right,
don't know
but
what it doesn't say.
right, but
It
he's also
doesn't say what you're wanting it to say.
but if he's testifying at his deposition that it's 400 pounds and it's 20 feet long, but then he goes to the doctor and says that it's a small pipe, okay, that's a contradiction. And also, a small pipe is probably not 400 pounds.
Counsel, you're talking science here. You know that the weight of things is relative. You're making assumptions that we can't make.
Well,
We're talking about liability, not damages.
sure, but then why is
I know you're not asking me a question.
No, but I'm saying I don't think plaintiff's testimony should be credited that it's 400 pounds if he never saw the pipe.
Is it rebutted that it was 400 pounds?
No, but I don't think it's established.
No,
as a-
but
Well, it's not established. He didn't weigh the pipe, right? I mean, and he never saw it fall. He got hit with the pipe, and then that's all we have.
the fact that the plaintiff, who has his back to the pipe that falls on him,
Right.
can't exactly describe every single aspect of the pipe is dispositive. This is how are we supposed to really adopt your argument?
I think under case law from this department, it raises an issue of fact regarding whether or not the elevation-related risk is de minimis. Under Macarius,
What about Villanueva? I think that's cited by somebody. There was a 500-pound I-beam, right?
right,
And it fell 6 inches.
right. But there's also case law from this department, like Peters and Macarius, where a 600-pound transformer falls less than 2 feet, and there's an issue of fact regarding whether or not the fall was de minimis. So in this
Sounds
case,
like you're arguing damages.
I'm not.
How badly was the plaintiff hurt? Given your argument, this thing was a small pipe, a skinny pipe, couldn't have weighed very much, so he couldn't have been hurt very much. And a jury can look at it and say, hey, you're right.
I disagree. I think that the de minimis doctrine is a liability defense, and that's, the 3 or 4 cases I cited in my brief.
So to rephrase a question asked by my colleague, what were the injuries? A fractured vertebrae. What else?
I don't know, but we're not.
Isn't that helpful, though?
It's helpful, but it
When you're
goes.
discussing de minimis, it's a nothing.
I'm not saying it's nothing, but I'm saying we have a plaintiff who doesn't know what happened. We don't actually
Is that
know the weight of the
dispositive
pipe.
that a plaintiff cannot describe the mechanism of injury as precisely as you're suggesting?
I think it raises an issue of fact as to whether or not he's entitled to summary judgment under the labor law, under the case law of this department, as cited in my brief. Thank you.
Thank you, counsel.
Very, very briefly, as Your Honor has pointed out, it is clear and unrefuted that the pipe struck the plaintiff, fell and struck the plaintiff. Issues of whether the excavation was 4 feet deep or 5 feet deep is not a relevant question of fact. And it is undisputed that the pipe weighed 500 pounds. It was described as
Is it
small.
500
I'm
now?
sorry, I apologize, 400 pounds. The undisputed testimony
What
is
about the medical record, of course, that they say you offered in another proceeding? Was that the workers' comp proceeding or something?
I'm not sure what was meant by that, but if to put it in context, the 9-foot section of pipe that struck the plaintiff was cut from a 20-foot long section of pipe. So it was relatively small to the section of pipe that it was cut from. So I would disagree with my adversary's characterization that's in some way inconsistent. And regardless of its length, if it weighed 400 pounds and fell 4 to 5 feet, that's in no way de minimis.
What's the diameter of the pipe?
I believe it was a 3-inch diameter cast iron pipe, Your Honor.
Thank you, counsel. Thank you all.
Thank you, Your Honors.
People v. Anthony Vega. Please.
Good afternoon. On behalf of Anthony Vega, Phoenix Rice Johnson. Mr. Vega's conduct in this case was completely aberrational. 2 experts who evaluated him determined that he is not sexually attracted to children. He procured child pornography only after entering a delirious fantasy fueled by methamphetamine use.
How long did he have this delirious fantasy?
He was they determined that between May and I believe it was August of 2020, that is when the instant conduct happened. But prior to that, he had no history of preoccupation with pornography or child pornography and no prior.
And as a result of this delirious fantasy, did he possess large quantities of child pornography?
I believe that the number stated in the case summary was something like 600 images, Your Honor. There's no doubt that this was extremely serious conduct.
And did he exchange some of that, some of those images with other people, including a person that was either 15 or maybe less than 15?
I believe he did exchange images with others. I don't know that he actually sent any to the individual he believed to be a minor. But I just want to be clear here that the experts found that if he were to comply with treatment, he posed, quote, no risk to the community.
It's a big if, right?
It is.
That's a big if, and that's precisely what I think Slaughter's aimed at. So if he derails in his drug treatment, which is part of the course for drug treatment, then the risk reappears, doesn't it?
It does, but his conduct here demonstrates that he's actually fully capable of complying, especially in his post-sentencing conduct, a period of over a year. He showed a truly...
Just 1 year?
And even prior to that, there was evidence that he was on a positive trajectory. The sentencing court actually said anytime he has fallen off, he has gotten back on, he's on a positive
So
trajectory.
he has fallen off already.
That was in his early stage, immediately after immediately after first being contacted. But post-sentencing, he had perfect attendance in a years-long individual counseling in sex offender treatment. He complied with a 7-week group therapy treatment, and he complied with regular drug testing and had absolutely no issues. He also complied with polygraph testing. He enrolled in a GED program, and it's clear from his own words that he has really benefited from this treatment.
So here, where the risk of reoffense is directly tied to sobriety and where there have been relapses in the past, I mean, obviously in the past, you're arguing that he should be, his SORA level should go from level 3 to level 1, notwithstanding the fact that he exchanged photographs with approximately 11 people of videos of children between 1 and 3 years old engaged in sexual conduct with adults.
I mean, again, it is
Adult males.
It is extremely serious conduct here, but I think he has demonstrated an exceptional rehabilitation, and even the board suggested a risk level of 2. A level 3 is the highest level, and it overstates his risk to the community. He's also at the extreme low end of that risk, and if this court would like finds that a downward departure to a different level is appropriate, we would of course be very grateful. Thank you, Your Honors.
Thank you, counsel. Next up is Continuum Energy LLC and John Preston v. Iron Oak. Please.
May it please the court, Gabriel Berg, Haynes Boone, for the appellants. I want to start, Your Honors, with why we're here today. At the record on pages 119 and 120 is a profane, threatening, and unhinged tirade by Rajiv Gosain, a defendant and a representative of all defendants, directed at my colleague, Eric Lindenfeld, counsel for the plaintiffs. Setting was a third-party deposition noticed by the defendants.
It was a remote deposition. We agree absolutely that the conduct was reprehensible, but was it repeated after that?
No, Your Honor, no, but here's the point. The case law, first of all, let me say with the trial court, how the trial court evaluated it. He said it was inexcusable, abusive, and clearly improper, threatening, and entirely
No,
inappropriate.
we read what he said, and he said that if it was done in court, you know, the court officers might have gotten involved, or
It would go to Rikers. And once the court makes those statements under a case called Ray versus Ray, which is directly on point, and let me tell you what happened in Ray. The trial court said the deposition misconduct was entirely frivolous, abusive, and fabricated, and then did not issue a sanction. This court reversed and said the lack of action is an abuse of discretion under Ray versus Ray.
Ray is remarkable for that very fact, because we don't generally do that. So Ray was pretty egregious.
Your Honor, at our brief on pages 4 to 6 are a series of cases that follow Ray. It was egregious here. If you read the tirade and the cursing and the threatening.
Oh, we read it.
We did,
Let's-
and we
let's
read
just-
Kettle
let's be
Rock, we
clear.
read
We
Cassini.
definitely read it.
I won't read
All
it,
the
I,
cases.
I promise.
Does it matter, counsel, that at a later time, the conduct was able to be curtailed with the microphone being muted, and ultimately the depositions went on? And
No, Your Honor, and I'm going to tell you why. Under the sanction rule, that doesn't matter. Once the tirade is on the record, and it was on the record, and all he had to do was stay quiet. Under the cases that I've mentioned already, it must be reversed because it's an abuse of discretion not to sanction someone who behaves this way. And what's
Does the
important.
sanction have to be the striking of the answer? Can it be something else, a monetary sanction, something short of gutting the case for the opponent?
It could, Your Honor, but the court dismissed a monetary sanction, and this is probably the most important.
Was the
Is that
monetary
because of you? Sorry.
No, Your Honor, he misunderstood my argument. I said,
We need clarification here.
sure. I said very clearly, monetary sanctions don't work with this plaintiff. He's been sanctioned all across the country.
So 1 second then. So if you said monetary sanctions don't work here, does that mean that the only option available to the judge was to strike the pleadings?
No, it's not. You're right. The only option wasn't to strike the pleadings, and this court has.
Was or was not?
Was not.
Was not.
There were all kinds of things the lower court, the trial court could have done, but doing nothing is not one of them. There are all kinds of things this court.
Did you give up the possibility of imposing a monetary sanction?
I did not, because the argument is preserved within our papers in the trial court. We said, at a minimum, monetary sanction. What he said was, seems like you agree with me that there is no monetary sanction. That's not what we pled at all, and that's not what I said on the record. On the record, it was a monetary sanction hasn't worked. And Your Honors, this is the problem here. There's no deterrent for this defendant. Monetary sanctions of $75,000. This court looking at his counsel and saying, your client's playing a game in our courts. He's been doing it in Texas and got his pleadings struck. One of those, he also was found to have defrauded the court, filed false
We did see all
affidavits.
that. Was it necessary, though, we didn't talk about this threshold issue, to first for you to put an affirmation of conferral, that you tried to work out this discovery dispute? I know that you say that under the sanctions statute that you don't need to do that, but it seems to me that since this pertains to discovery, you do have to do that. So tell me why I'm wrong.
Because the sanction statute first, we moved on two grounds. One
Yeah, I
was the
know, I
sanction
know.
statute, one was discovery. But the lower court did not consider this argument, did not put it in his opinion, and he dismissed it out of hand below. It wasn't part of his opinion.
Yeah, but it's kind of on the face of the record. It's one of those legal questions that is like a threshold question. You know, like, did you do an affidavit of conferral or not?
We didn't, by the way, we did put in an emergency affidavit and the answer in response to my emergency affidavit wasn't, hey, you didn't meet and confer with us. What is there to confer over? There was a tirade. What, is he going to take it back? That's the last point I want to make. He is unapologetic to this day. The trial court wanted an apology. The one thing I would have done if I were in his shoes is apologize to this court. He's abusing the
Counsel, you have
system.
time to rebuttal. Thank you.
Good afternoon, Your Honors. Thomas Butler from White and Williams for the respondent. Your Honor.
So, assuming that an affidavit had been properly put in, why isn't this sanctionable behavior, or is it the degree of sanction that we're talking about?
I think it's not sanctionable behavior.
Really, during depositions, you could just curse out
No,
everybody?
absolutely not, Your Honor. I mean, one of the things we have not done, and we were very clear on the record, and I'm going to be very clear today, we are not excusing this behavior. I think Justice Cohen got it 100% right when he said, I'm not excusing this behavior. I think this behavior is outrageous, but he also noted that there was provocation. He noticed there was a lack of civility on the other side. And Justice Cohen didn't do
When
nothing.
you say lack of civility, do you mean the question, sitting here today under oath, would you still stake your own name and professional reputation on Mr. Gosgain's honesty? Is that what you call provocation?
Yes, Your Honor.
And you think that that was sufficient to provoke this kind of language and these kind of threats?
That's not what we're saying, Your Honor. What we're saying is that throughout that deposition and other depositions in this case, and we pointed out in the next deposition after we had agreed to mute Mr. Gossain's microphone, and we did that voluntarily as a way of addressing this, they actually showed a clip this is to a third-party witness, fact witness, a clip of an argument in the appellate division over the last sanctions issue. That's inappropriate. It's inappropriate questioning. Nothing justifies.
Is that the issue before us?
No, that's not the issue. But it's not the issue before us, Your Honor. But what is before you is whether or not Justice Cohen abused his discretion. He took into account everything here. And as I was going to say before, he didn't do nothing. He issued an order in which he said, this is reprehensible, don't do it again. He specifically said on the record, this better not happen again. And that's something, because that's a warning that, hey, next time I'm not going to be quite so kind.
It's a judge making a record, essentially.
Well, he's making a record, but he's also putting the defendant on notice that, hey, this didn't rise to that level where I'm going to strike your pleadings. But you know what? If it happens again, I might not take the same view. So he certainly did something, but he also did note that there had been some lack of civility, and he spent 3 or 4 pages going through that. So I think that he certainly understood the situation. And with respect to the tirade, and again, I'm not excusing it, but the reality here—
Mr. Wells was his lawyer?
Mr. Wells?
Yes.
Mr. Wells is my colleague.
Huh?
Welch or Wells?
Wells.
Wells is the attorney who was defending the deposition.
Right.
He's my colleague.
And Mr. Gosgain says, Mr. Wells says, Rajiv, please, to try to stop him.
Yes.
Right? And Mr. Gosgain says, I'll deal with you. Otherwise, I will shut this deposition down in exactly 1 minute. Did you consider that simply objectionable behavior that should be, given a little warning, like don't do it again?
I think that what I consider that to be, as I said before, is inappropriate, but I think you have to look at the entire picture. The deposition wasn't shut down. The deposition wasn't interrupted.
Because he was muted.
Well, no. He was not muted that time. He was muted for future depositions. That time it was simply stop, and then we moved on. And the cases that were cited in the appellant's briefs were generally—
I think we could all agree that the language, the conduct was inappropriate.
Absolutely.
And by the court just giving its, however you want to phrase it, a warning, don't do it again. Aren't we telling parties, you have one shot at acting inappropriate?
No, I don't think that's the case at all. And again, I think if you look at what the court did here, you have to look at the entirety of this. He did not.
When you say the entirety of it, that sounds to me like you're trying to justify his conduct.
Not
And
at
I think
all.
and I think if you take his conduct, there is no justification for it.
We are not trying to justify his conduct. And as I said before, I agreed with Justice Cohen's determination. Nothing justifies the conduct, but we still have to consider the context in which it
So
arose.
Mr. Lindenfeld was who?
Was.
Mr. Lindenfeld was who? That was plaintiff's counsel, right?
Yes.
And Mr. Lindenfeld says, "Are we done?" And Mr. Goskane says, "This boy, I'll deal with him."
It was inappropriate. Your Honor, we are not excusing the conduct, but the question here is, does he get his pleading struck? And if we look at the case law that was cited, those cases were far more
Should the judge have
egregious.
issued some other penalty other than striking the pleadings?
Well, Justice Cohen considered that, and not only leaving aside Mr. Berg stating quite clearly on the record, monetary sanctions don't work, which I do view as abandonment, he also said there's no way that we can come up with a monetary sanction here, because how do you, I mean, under the sanctions rules, monetary sanctions have to be compensatory. They're not something you give out to punish people because they were bad. That's what Justice Cohen said, and I would submit that I think he got it perfectly correct. He laid out the warning, and since then, there have been no repeats of this conduct.
Thank you, counsel.
Thank you, Your Honor.
Thank you, Your Honors. I'll be very brief. First of all, in the next deposition, he behaved himself. That's outside of the record. How could it possibly be inside of the record? They cite two docket sites left, right, and center to try to prop up the notion that this was okay. Judge Cohen, on the first sanction order, gave a warning to the defendants. He said it was their last chance. He said, this is at the record 558, "I think you should look at this as an opportunity to avoid worse sanctions." He's already warned them. This is Texas redux, except Texas struck his pleadings quicker. How many chances does a litigant like this get in our
So that's always the question. And it's a very difficult question for a trial judge, but we give a great deal of discretion to trial judges, don't we?
Of course, and there are lots of things that could have been done, Your Honor. One, he could have found liability, moved to a trial on damages. He could have given a monetary sanction. He said he couldn't figure out how to monetize a sanction here. He really should strike the pleadings, given his own warnings. This is your last opportunity. He said, walk out of this courtroom and exhale. That's what he said on the first sanction motion. How many chances do these people get? And here's the biggest problem, and this is the most important point I can make today. If this court doesn't stop this defendant, we'll see you back here very soon. He has acted inappropriately throughout the whole litigation.
Counsel, just like trial judges are not clairvoyant, you and I are not clairvoyant either. We don't know what's going to happen next.
No, of
You
course
can
I don't
predict
know.
that.
I don't know for sure. I'm not predicting the future. I'm saying based on his past conduct everywhere, how could we not if he behaves the same way?
Are you saying that it was an improvident exercise of discretion by Judge Cohen and not having stricken the defendant's pleadings at that time?
No, I am saying it was an improvident use of discretion not to do something. And that's what Ray versus Ray says, and that's what all the other cases say. But, Your Honor, under these circumstances where we're at our wits' end, and this court was at its wits' end the last time we were here on the $75,000 sanction for not participating in discovery, what else can we do to stop this person? Do these defendants deserve this court and their forum here based on how they've treated the courts? And the court and its dignity is at issue on this appeal.
Thank you, counsel. Thank you both. Tejada v. 57th and 6th Ground, LLC.
Your Honors, may it May it please the court to Barak Bacharach on behalf of ASK Standard Transit Corp., appellants ASK Standard Transit Corp., Asin Kostadinov, and Go New York. So in this case, both the third-party plaintiffs and the third-party defendants admit that at the onset of this case, counsel for the third-party defendants offered to indemnify and defend the third-party plaintiffs. The question then becomes, were the third-party plaintiffs entitled to reject that reasonable offer? And the answer to that question must be no. It is well settled that that an insurer's duty to defend is exceedingly broad, but a non-insurer's duty to defend is narrower. And even in the case of an insurer whose duty to defend is exceedingly broad, there is no counsel of one's choosing absent a identifiable conflict of interest. There is no conflict of interest in this case which would justify third-party plaintiffs are requiring their own counsel. The counsel for third-party plaintiffs claims that they couldn't be assured that counsel for third-party defendants would provide an adequate defense if indeed they were not on the hook for the outcome, but they ignore that there is indemnification provision at issue. And in the offer to defend, the third-party defendants also offer to indemnify. So,
you see, your client has a workers' comp defense, which they do not have, correct? He was ASK's employee or ASK's employee, correct?
yes.
Okay.
Yes, he was, Your Honor.
And so I thought you reserved the right to raise that at some point that, that you had a workers' comp defense, which would not be something that the landlord could assert.
Yes, but there's also the indemnification provision at issue. And in the offer to defend, there was also an offer to indemnify. So if indeed ASK Corp. would make that defense, they would still be liable via the indemnification provision.
So you're saying they waived their contractual indemnity because the lawyer made some offer, which is not entirely clear from the record, that he was going to defend them? That's it, right? That's your argument?
We're saying that we waive their right to retain separate counsel.
Okay.
Isn't there a conflict of interest, potentially?
You're
saying that they waive their right to retain their own counsel?
Yes.
Insurance counsel, as opposed to the counsel for your client?
I'm saying that counsel for our client could have, if they had accepted the offer, ably defended against the plaintiff's claims, and there's no
conflict of interest?
No. Where's the conflict of interest? Your colleague is correct that my client, absent the indemnification provision, could have asserted that workers' compensation was the sole remedy, and we do plan on asserting that defense. But still, there's the indemnification provision. And if the offer was, and as they admit, that the landlord defendants, this is an affirmation from the third-party plaintiff's counsel, the landlord defendants acknowledged that during one conversation, counsel for the third-party defendants mentioned they would indemnify the landlord defendants. So if we had already accepted that indemnification provision, there's no conflict of interest there. I also want to briefly turn to one other issue, which is that the regulation that, frankly, we believe forms the basis for both the 240 and 241 claim, to the provision of the industrial code, conflicts with OSHA regulations, right? The Supreme Court is clear.
Counsel, you're way off base with that one. I wouldn't waste any time on that whatsoever. We go by the industrial code, not what OSHA says. So move on to your next argument.
Okay. Well, I would say also...
You want to talk about 240 sub 1 as opposed to 241 sub 6?
I'm talking about both, and I think
let's talk about 240 sub 1.
Okay.
The OSHA provision has nothing to do with 240 sub 1. There's case law that says that. So I wouldn't hang your hat on any OSHA provision whatsoever. Was there a gravity-related risk here?
As far as I'm aware, this court has never considered whether a certain provision of the industrial code...
Counsel, you can stay in that argument and talk as long as you want, but I'm telling you, it's not going anywhere. So maybe switch to another argument.
Yeah, and I want to just call your attention to Bland versus Manacharian, a Court of Appeals case in 1985, which said that 241 requires scaffolds to be constructed and erected so as to give proper protection to workers without regard to height. And I think that's somewhere that, I think that you were also hanging your hat on the height issue, that the platform was 6 feet instead of 10 feet. And as my colleague has indicated here, OSHA doesn't work here. Not for these purposes, but.
Just to respond briefly to your point, Your Honor, I think Bland in many ways supports us. It specifically held that Bland affirmed a jury verdict, which held that the issue of proper protection was an issue of fact for a jury. That's what we're arguing. This is a case on summary judgment.
The path that you're going down and what my colleagues have been explaining to you, again, is that we have so much case law that deals with this issue and does not stand for the proposition that you are now again trying to ask us maybe to revisit, but we're not going to. It is what it is.
Think about what other arguments you want to make, counsel, on your rebuttal time. Thank you.
Thank you, Your Honor.
May it please the court, my name is Daniel Kotler from Lester Schwab, Katz and Dwyer. I'm counsel for defendants, respondents, appellants, 57th and 6th Ground LLC and Carnegie House Tenants Corporation. I'd like to focus my time here on responding to the indemnity claim, which is a strange argument that the tenants insist upon. They admit that the lease obligates them to indemnify and defend the landlord. They make this big production about having offered, there was apparently a telephone call and their tenants counsel made some unspecified offer to take over the defense and provide indemnification. But when my colleague, when Ms. Summers asked, she didn't reject anything, and they have put in no evidence of any rejection. She simply asked for clarification. What would this offer entail? What are the circumstances? Is there a reservation of rights? Can you please put something in writing?
Also, what happens if you lose? I mean, you know, indemnification is not only defense costs, but also like you on the hook for what you have to pay the plaintiff.
Exactly, Your Honor. So all of these were issues. If there had been an ironclad offer of, yes, we'll pay everything, we have the resources to make sure it happens, that might have been a different situation. But the tenant defendants insist, on the one hand, oh, we offered, and therefore you waived it by rejecting it. But if this offer were real, why did they never provide specifics? Why is it not in writing? Why are we here today on appeal having this argument at all? On the question of conflicts of interest, Your Honor mentioned workers' comp. There's the issue of common law indemnity and establishing the landlord defendants establishing that nothing happened as a result of their own negligence. There is a question of who has money available and whether things could be paid. There's this very simple question that, however meritless the tenants' cross claims were, they were asserting their own claims against the landlord defendants that they had, the landlord defendants that they hadn't dismissed. So for them to say that there's no conflict of interest while having claims against the landlord simply makes no sense. And ultimately, even if they had no, even if the landlord defendants acted unreasonable in having their own counsel, which I don't think they did at all, and I've argued here that they were not unreasonable, but even if that were true, that's only a question of the extent of the reasonable attorney's fees to be reimbursed. It does not in any way affect the obligation to indemnify in and of itself, nor does it even undermine the question of entitlement to reimbursement of fees and defense costs. It's just a question of how much. If Your Honors have no other questions, I think you have my arguments. Thank you, Your Honors.
Thank you. Please.
Good afternoon, Your Honors. May it please the court, Anthony DiStefano for plaintiff respondent. There is no new novel theory of liability here under Labor Law 240 sub 1. My client inadvertently walked off an unguarded scaffold platform while he was performing his painting work. And under this court's decision in Vergara and countless decisions since, that has resulted in a finding of liability for a violation of the labor law against the, whether it be owner or contractor defendants. And there's no reason that any result should be different in this case. And for that reason, we ask the court to affirm. Unless the court has any other questions, I'm happy to.
The ASK defendants have this idea that it would be a taking if we required guardrails around scaffolds. Was that argument made below?
I believe it was made below, but whether it was preserved or unpreserved, the simple result is, the Court of Appeals has said that, the state has an interest in protecting workers in its state, and the industrial code is a way of doing that. And the industrial code is promulgated by the Commissioner of Labor, and who sets forth various standards that owners and contractors must comply with, and there's nothing unreasonable about that. It does not result in a constitutional taking. It just simply is the one method used to go about protecting the workers of the state.
Thank you, Counsel.
Thank you.
Your Honors, so I think that the colleague for the third-party plaintiffs was, at least in my mind, confusing some of the issues. The defense against the plaintiff's claims, which is what we offered to take on at the beginning of this case, is the same. And we know it's the same, because on this appeal, counsel for third-party plaintiffs didn't put any argument against it. They joined our argument. And that's been our point from day one, that the arguments as to why neither the third-party defendants nor the third-party plaintiffs are liable to the plaintiff are the same. And I want to be clear, the cross claims that he referenced did not exist until they unreasonably refused this offer. That is the genesis of those claims. Lastly, an offer doesn't need to be, I'm analogizing this to contract law, but an offer doesn't need to be in writing for it to be definite, right? At the very least, there's a factual issue here. If both sets of counsel admit that an offer was made, and that's at R1392, right? The landlord defendants, I mentioned this earlier, sorry, that's at R1348. They put an affirmation saying an all offer was made. That is at the very least a factual issue that is inapposite for summary judgment. Lastly, with regards to our takings clause, we don't dispute that the state has, of course, the police power to set reasonable regulations. But the state can set reasonable regulations without flatly banning the most common scaffold used in the United States.
The argument is it's a taking because you can't use scaffolds anymore? Is that what you're saying?
You can't use the most common scaffold in the United States for the purpose that it was sold for.
Any thought about retrofitting scaffolds that don't have guardrails with scaffolds that do have guardrails so that workers don't fall from them? I mean, that's not a taking, that's a retrofit.
Well, actually, I think the case that we cited regarding ship hulls, costly retrofits were held to be a taking. There's a Federal Circuit case about that. There's a Federal Circuit case that about how, I think Lucas v. South Carolina, and also Duncan v. Barrera. There are takings clause case that says the costly retrofits can, in fact, be takings. So I think that helps us.
Okay, thank you, counsel. Thank you all.
Thank you, Your Honor.
Yolanda Management v. Macroalgo. Microalgo.
Good afternoon, Your Honors. Lawrence Yuan for Appellate Microalgo. I will focus on 3 points very briefly. First, taking everything in the complaint as true, plaintiff's breach of best efforts claim is fundamentally about timing and speed. It is not we did not make any efforts, but more accurately, we did not make any efforts as of now.
Counsel, you rely on Timberline, right? That's one of your cases.
Yes.
Now, doesn't the RRA here provide more specific and objective obligations concerning best efforts?
The only qualifier for best efforts in the RA is as expeditiously as possible. It is essentially saying we can't agree on a deadline, we don't know what a reasonable timeline looks like, and defendant now is too slow to act, and so judge, you should go figure out retrospectively what parties can agree on. So we do not believe there is a objective time criteria to measure the best efforts.
Any further, explanation of the word expeditiously by a following provision that said defer any demand registration up to 30 days in any 365 day period?
That's a very good question, Your Honor. We actually addressed that in our brief. If we have a close parsing of the contract language, the word demand registration is defined in 2.1.2 of the RA. And it says a registration is not a demand registration until it is effectuated. So demand registration means effectuation, not filing. This is also evidenced by the fact that Section 3.1.1 says that after respondent's request for demand registration, microalgo can defer for 30 days, and the reason for such deferral has to be that for such registration statement to be effected at such time, not filed at such time, would be materially detrimental to the company. It does not say filed at such time. And last point, the 3.1.1 itself differentiates between request for demand registration and demand registration.
Did your client make any efforts, much less best efforts, to do anything to register the shares?
No, Your Honor. In a complaint,
Is that an answer no? Did you say no?
Yes, no. There's no efforts made alleging a complaint as of now.
Okay.
Our point is it is a speed question. The contract.
Sorry, but your point is what?
It is a speed question.
Speed.
Yes. It's how fast we should act to accomplish filing of the registration
So
statement.
what's the difference between acting as expeditiously as possible and doing nothing?
Yeah, so the parties are clearly aware of the speed problem. And that's why they put in a vague phrase, as expeditiously as possible. And it's our argument that parties have actually waived the right to have this clause being enforced by the court. And the reason for that is,
Please.
This is a motion to dismiss.
yes.
Is it not adequately at least pled, this breach of contract claim, and maybe on summary judgment, maybe with more information, you'll do better?
Your Honor, if all plaintiff has to do is to allege there are no efforts made, then we effectively do away with the clear guideline requirements under the First Department rule. And the parties could just throw in best efforts clause, however vague it may be, and then litigate and clog the court with more endless lawsuits like this one, and let the judge figure out retrospectively what parties can agree on themselves. Thank you.
Thank you, counsel. You have time, rebuttal.
Good afternoon, Your Honors. Mastawal Tadesse Tarefe for respondent.
So counsel, just picking up on that thread, this being a 3211 motion, and you have to plead adequately. If there's no real issue as to what the best effort is, or you can't discern it, how have you pled it adequately?
Yes, Your Honor. In fact, we have an agreement that has a very clear timeline for the filing requirement. The other side is trying to confuse the panel, and I just also want to point out that there's a related case that this court heard a few weeks ago. Judge Gonzalez was on the panel, I believe. Similar facts, same language, same contract, the same type
Talking about the
of
Greenland case.
Correct, Your Honor. And as I pointed out at that argument, if you look at 3.1.1, it lists the three obligations, Your Honor. The requirement to prepare and file, the requirement to make a statement effective, and the requirement to keep it effective, and then puts a semicolon saying, provided, however, that the company shall have the right to defer any demand registration. So clearly from the punctuation and the clear text of the contract, the requirement to file is also subject to the 30-day proviso, and that means the preparation and filing obligation had to be made by the 30-day deadline. And in fact, even that 30-day deadline is triggered only if they meet a bunch of requirements, including providing my client a certificate that explains why deferral is necessary and that they can only do it once a year. So going back to your...
When your adversary talks about speed, that the issue here is speed.
Yes.
Are you saying that the 30-day proviso is a mark?
It is a clear mark. This language is not confusing. It does not require external references. It has a semicolon, which means that it qualifies everything that came before it, and then says all these obligations can be deferred only for 30 days. So I know the briefing, we kind of helped their point by arguing their cases and citing additional case law, but it doesn't even require reference to other cases that involve best effort. It's a very clear language that requires them to do it within 30 days. They have not done it. And as the previous panel that heard a similar case asked the other side, the fact here is nothing has been done, no effort.
Was there anything, is there anything in the record to indicate that providing the registration statement would be materially detrimental?
No, Your Honor. In fact, no substantive response at all. And I'll refer to the record a few times. There's the lower court specifically asked the question that Judge Gonzalez asked in the previous hearing, did you do anything? And counsel at the time said, no, we did not. It's a clear thing. 3 demands were made, no answer, no action. The record reflects this at 20, the oral argument transcript, and then also at page 24, a clear admission that the allegations, no effort has been made, and in fact, at that time of that hearing, also no effort was being made. So just to distinguish the cases that they cite, I don't think we even need to get into the case law because this is a clear contract on the face. The cases they cite are internal memos, brief citations to vague language to promote something or to retain a candidate, language that's very broad and doesn't have a clear term defined. They're relying on those cases to say that a clear registration right agreement, which is the whole essence of the parties' relationship, is for my client to organize this company, get it listed, and once it's listed, they can exercise their right to trade their shares. They invested significant amount of money to organize this company and get it listed, and once it's listed, the other side is saying, we're locking your shares and we won't be registering them and we won't allow you to trade them. And that means millions of my clients' value has been stuck for many years. And again, the record here in terms of what the lower court also questioned the other side about is very abundant. There's no allegation here. So I'll cite to a few things. Record number 99, page 99 to 100, it shows the proof of the written demands that we made, and no response to that has been furnished. And then also record page 20 and 24.
You set those out very well in your brief.
Okay.
Thank you.
Okay, thank you, Your Honor.
Your Honor, just two very brief points. One, I just want to clarify what our understanding of how the clause operates. So the clause essentially says, plaintiff requests for effectuation. We prepare and file as expeditiously as possible. And after we file, and the FCC is poised to declare the registration statement effective, we can defer it for 30 days for the reason that is solely that is materially detrimental to the company.
But you deferred it till forever. There was no response.
The deferral only qualifies effectuation, does not qualify filing. That's the first point I want to make.
I'm sorry, what is the distinction that you're making?
The distinction I'm making is the 30-day deferral only qualifies the obligation to cause a filed registration statement effective, not the filing obligation itself. Because if the 30-day deadline is really qualifying the filing, why not just say, we should make best efforts to file within 30 days, which is a very common and standard language in any contract to register a security.
So you do acknowledge that there were written demands served for the registration.
That was alleged in a complaint, yes.
Statement, and here the language is clear: the right to defer any demand registration. So
the demand registration is defined as an effective registration. It's defined in 2.1.2. So it's basically a very textual interpretation. We're not trying to change the parties bargain. Parties bargain is this clause, the best efforts clause is not enforceable in court. This is after both the state and federal appellate court has said similar vague category of languages, like as close as possible, as far as possible, is not enforceable. And this agreement made in 2021, after those cases was decided, I don't know how else can we opt out of court enforcement and waive the right for the court to enforce the best efforts clause. That's all. Thank you.
Thank you, counsel. Thank you both. Prof 213-S3, legal title, Trust v. West Fork. You're here for Prof, right, counsel?
For Appellant West Fork.
Ah.
Funding. May it please the court, Christopher Volante for Appellant West Fork Funding. The court obviously is well aware of there's many issues raised in this appeal, but what I want to focus my limited time on is the clearest, I think, red light here is the plaintiff's failure here to meet its burden to prove a lack of willful neglect in the prior foreclosure action. I mean, here you have an undisputed situation of a property owner who owned the property prior to the original foreclosure action, who was not named as a party and never was. And so it's their burden here on reforeclosure under RPAPL 1503 to prove a lack of willful neglect. And here they fail that on both an evidentiary basis as well as on the substance. Evidentiary-wise, here the plaintiff was not a party to the original foreclosure action, and the only affirmations and affidavits they submit are through their current attorney and their current servicer, again, none of which were parties or attorney or servicer in the original foreclosure action. So there's no personal knowledge here. So to the extent that they try to espouse a lack of willful neglect here, they would have no idea. They don't know what they did, when they did it.
Counsel, she's competent to say when they did their title search, right?
You can certainly say when they were done, but
So, you know, to draw the inference that a 4-month delay is not that important.
So
They invite us to do that.
Yeah, I'll address that as well. So not only was there a 4-month delay in failing to run a new title search, which is particularly, I think, egregious here when it comes to New York City properties in the Bronx, because we have Acris. Any person with a computer, in the time your honors are listening to me, you could search Acris and figure out who the deed owner of a property is. And there's no explanation as to why that wasn't done, why another title search wasn't done, when even the title search itself recommends doing another title search before a lis pendens is filed. And in here also in the prior foreclosure action, the entity that ended up finishing the actual action.
Say they're a little lax. I mean, say I grant you that they're a little lax. Are they just out of luck then? And then you guys own the property?
Well, I think there's some there's some factual analysis that needs to go into every scenario here. But I would say here, given the totality of the circumstances in particular, you don't meet that standard. They hang their hat on Guardian, for example, which is a third department case, as standing essentially for the proposition that if you run a title search a couple months before, you're absolved from the idea that there's willful neglect here. And that's clearly not the case. Guardian, in and of itself, clearly factually distinguishable, because there, the mistake, the neglect, wasn't with the actual foreclosing plaintiff, it was with the title company. The title company messed up and failed to identify the relevant interest. So to me, Guardian stands for the proposition that if you're misled by your title company, and that makes sense because the plaintiff itself wasn't neglectful, that there's no willful neglect. But that's not the case here. The title company didn't miss
Counsel.
anything.
Thank you. You've gone over your 2 minutes.
Thank you, Your Honor. I appreciate it.
Any other questions for counsel? Okay, thank you, counsel. Next case, Justice Gonzalez is recused on. It is Kennedy versus Archdiocese. Please.
May it please the court, Your Honor, John Lovelace for the appellant, the Archdiocese of New York. There's a very specific issue before this court this afternoon, and it rests on the nature of the court's orders in total. The additional deposition of Douglas Mathers is entirely without purpose.
Other than the fact that the witness who testified before said, ask this guy, he knows everything?
He said maybe Douglas Mathers, after confusing questions about canon law 489, and Douglas Mathers is a canon law scholar, not an archivist. But more importantly, Your Honor, to the point is, the court has issued a specific order prior to Bishop Walsh's deposition. And that said that, and this is record 106, that the Archdiocese is to produce any other documents relating to Monsignor Hyde. In the document demand, it's specifically named secret confidential files. The files that counsel is seeking to uncover is already the subject of the court's order and has already been directed to be produced. So if this...
I would say that the deposition topics in the Mathers notice of deposition is a little more specific than just secret. It mentions canon 489. So does that make a difference?
No, because canon 489 is a subset of the files. and the notice to take the deposition of Douglas Mathers is virtually identical to the other 5 witnesses that were noticed at the same time. They're pretty much the same set of notice to take depositions. Canon Law 4, if you read the briefs and the motions, they're not seeking to depose Douglas Mathers on what Canon Law 489 holds. They're seeking to depose him on whether or not he knows whether there are Canon Law 489 files and where they're kept.
Well, particularly, pertaining to Mr. Hyde, Monsignor Hyde.
Yeah.
So do we know if Canon 489 files are the same as secret files?
No, they're not.
They're not. So they want to know what Canon 489 is, what would it be included in those files within Canon 489,
correct,
and whether or not these are files that they could somehow obtain discovery on.
Right, but it would still be included in the court's order that all the documents relating to Herman Heidi be produced, whether it's sub secreto, secret, confidential, Canon Law 49, personnel, whatever you want to call it. Whatever you want to uncover at these depositions is already encompassed by the court's order.
The prior order that you're speaking of, did it spawn any depositions? Were any depositions completed?
No, that order was issued and the records were produced to the court and ultimately to the plaintiff prior to the completion of Bishop Walsh's deposition.
Including files within Canon 489?
The Archdiocese doesn't have Canon Law 489 files.
It doesn't have that.
But, okay, so they were produced prior to Bishop Walsh's deposition.
Completion of it.
The completion of it. And in Bishop Walsh's deposition, when asked about certain things, he says, I don't know, I'm not the person, go ask this other person. And why wouldn't they be able to pursue that at that point?
Because by that point, what they're seeking has already been the subject of a court order.
But I'm sorry, continue, please.
My point is that if you played this out and Bishop and Douglas Mathers is produced, and he says either A, I don't know anything about it, or I do know. There's confidential files maintained. Where are they? They're maintained in A, B, and C. They're still subject to the order, and they would have been produced already.
Well, that's exactly what they want to get to, whether or not those files were actually produced pursuant to the order, or whether or not there's something else being withheld that they may be entitled to.
Right.
And so you're saying that they should take your word for it, that they've been produced, and they're saying, no, we want to speak to this particular witness to see whether or not they have been produced. Isn't that what's going on here?
And it's not as if it's a fishing expedition, shot in the dark. This particular witness that you decided to produce says, I don't know. Go and ask Mathers. He knows.
Respectfully, Your Honor, there's 2 things. First of all, there's also the affidavit of the archivist who testified about the extensive search that was prepared, and that was in lieu of her deposition. That wasn't the subject of this motion. There was a notice to take the deposition of the archivist. We produced an affidavit that outlined her search for the records.
You're talking about the Jackson affidavit now.
Correct. And that was sufficient for the defendant's purposes for her. Bishop Mathers, Douglas Mathers was named as somebody who might know more than Bishop Walsh, yes, but it was regarding the maintenance of...
I mean, Bishop Walsh didn't really know much about anything.
Bishop Walsh knew respectfully, Your Honor, if I could answer the question notwithstanding the time. Bishop Walsh was a seminarian, an associate pastor, a pastor, confidential secretary to the cardinal. He was an auxiliary bishop. He was rector of St. Joseph's Seminary, and he's been in the church since the late 60s, and he was well into his 80s.
Great.
He knew a lot about a lot.
But not the things that he was asked specifically, which is why he said, go ask Mathers.
Well, he did.
I mean, he was very candid in that.
Well, no, he did say he was not aware of these files, and they said, did you know somebody else, somebody more? And he did say Douglas Mathers, yes. But my point is that asking Douglas Mathers to testify about the potential existence of additional secret files when they're already the subject of an order.
You made that point very well. You have time in rebuttal as well, Counsel. So counsel, is this getting blood from a stone? You hear what your colleague said.
I did, Your Honor. Good afternoon. Jared Scotto for the respondent plaintiff grouping from Whites in Luxembourg. I have heard that, and it's something that I've discussed with Mr. Lovelace, but we go back to the original point that, that Your Honor made, that the name Douglas Mathers was interjected into these proceedings by Bishop Walsh. I believe that happened while I was questioning him. Canon Law 489, to my understanding, is the way that priests are disciplined and issues that have come up. Herman Heidi, the Monsignor at issue here, there are 5 Child Victims Act cases that are grouped together where Herman Heidi was the alleged abuser.
And we know that, but you heard, again, your opponent just said that the 489 files are a subset of secret files and therefore would have been produced.
That's correct, Judge. But there might be some information about how the Archdiocese handled 489 proceedings that Monsignor Mathers can shed light on. Herman Heidi was the subject of IRCP payments. There were complaints that were made about him. There's potential, and that's very much material and necessary to this case, about how that came about and how those decisions were made.
And those are the things that you want to explore.
That's correct, Judge. We had originally sought the depositions of 3 or 4 witnesses, I believe, whose names were provided by Bishop Walsh. Judge Krause split the baby, and she gave us 1 deposition. So we believe that the court below appropriately exercised discretion in overseeing this discovery matter, and we wish to question Monsignor Mathers about any potential 489 implications related to this abuser.
Thank you, counsel.
Thank you very much, Judge.
To the court, very briefly, the IRCP records was an independent program not maintained by the Archdiocese of New York, and those records have been produced. If you look at the motion papers themselves, the record before the court, there is nothing, the arguments raised with respect to Douglas Mather are specific to these confidential records. I apologize. Are these confidential records. The 489 issues, to the extent they want to be disclosed, is something that isn't even addressed in the papers. It's about records, it's about confidential files, and those were already addressed in the court's order. It wasn't about the addition, while it might have been laid out in the notice to take deposition, it wasn't raised in the motion below concerning in our protective order or in the brief concerning how and why Douglas Mathers was to be deposed. Thank you.
Thank you. Thank you both. People de los Santos. Please.
Good afternoon. On behalf of Jose de los Santos, Phoenix Rice Johnson. Officers presented Mr. de los Santos to the witness under extraordinarily suggestive circumstances. He was in handcuffs. He was held by officers on either side. There were 10 additional police officers surrounding him, as well as police cruisers.
But People v. Wright, which was a 4-3 decision, but still one binding on us, doesn't that say that, of course, there are going to be police officers around her to show up, and of course, someone might have handcuffs to show up?
People v. Wright and many other cases from both the Court of Appeals and First Department where there were similarly suggestive circumstances are distinguishable because there the defendant fled, and so he had to be restrained because otherwise there was no way of guaranteeing that he would be present for the show up. By comparison, in this case, the defendant was completely compliant. He did not flee at any point.
He didn't wait around, right? And he didn't flee, but he didn't wait around to be apprehended by the police.
As soon as the police approached him, he was compliant. They searched.
He's going to say he was completely compliant, because I think we've all watched the body camera video, right?
Right. He said he cussed a bit, but he, unlike in these cases, like Wright and other cases from the Court of Appeals and First Department, where there might be some factually similar suggestive circumstances, the client was evasive. He ran from the police. He may have fought back. And in many of those cases.
What about the fact here that he's accused of an attempted bank robbery?
Yes, Your Honor.
It would be reasonable to think that a weapon might be involved in an attempted bank robbery.
It would be if police had not already searched him and even gone into his pockets by the time of the identification. As soon as they apprehended him, they searched him, they went into his pockets, they found no weapons, and 10 minutes later, the identification happened. So they were aware at that point that he
Also,
was
we know
not-
that I think as a general premise, I think we will all agree that a show up is one of the more suggestive forms of identification. What happened here that puts this process over the top?
Nearly every suggestive factor
Everything that you've mentioned so far has been approved by the Court of Appeals in other cases.
in cases where there have been exigent circumstances that were not present here. In addition to the factors I just mentioned, the teller never actually saw the suspect's face because the suspect was wearing a face mask, a hood, and large reflective sunglasses. So the teller was likely even more persuaded by these suggestive circumstances. He was not making an identification based on some immutable characteristic like eye color, but simply determining whether or not Mr. De Los Santos was wearing the same clothing.
Yeah,
That
but
is
some
very
of the description,
concerning.
there was a bit of description that went over the wire that said the person had a mustache or some part of a mustache. And if you look at the video, you can see Mr. De Los Santos was wearing his mask a little bit below his nostrils. So
Yes, there were certainly slivers of features displayed, but here where everything is pointing like a blinking sign, guilty, I mean, he's held by officers. There were so many officers, in fact, that when the witness first showed up, he couldn't see Mr. De Los Santos because there was a police officer blocking his line of sight. And what the sergeant told the witness when he was being transported to the scene was additionally quite leading, saying that he would be able to identify the stopped individual as the male involved. Like every single aspect of an identification that can cause it to be suggestive was nearly present here, and it was completely gratuitous. Yes, under some circumstances, perhaps it is necessary for there to be a show-up identification with all of these security measures, but that wasn't the case here in Mr. De Los Santos's case because this was a circumstance where he was already under arrest. He had already been searched.
Counsel, do you believe that all show-ups are flawed by definition?
Well, that's certainly what the case law would suggest. I mean, they're largely to be avoided because they're so inherently suggestive. They raise the likelihood of misidentification. I think any common person, if we were to walk out on the street and see someone held by officers, the person's hands behind their backs and police cruisers surrounding them, couldn't help but have some inclination that that individual had likely just committed a crime. You know, I recognize that there are sometimes circumstances where the courts have found that such a show-up is necessary, but that wasn't the case here. There was no weapon. There was no attempt to flee. And there were opportunities for the officers to make such an inherently gratuitous procedure such an inherently suggestive procedure less so here. Thank you.
thank you, Counsel.
Good afternoon, Your Honors, and may it please the Court, Juliana Susu for the people.
Counsel, how do you respond to your adversary's position that no weapon, he wasn't fleeing, he's basically in custody? Why did he have to be in handcuffs?
The defendant was in handcuffs and there was police presence because it was a routine safety procedure. While the officers did not find a weapon at that time, it was an initial 1-minute search based on the video. And even in that search, they didn't find the money that was later on found on him. There was still the belief that defendant could possibly be armed. He was accused of committing a bank robbery. And it was on a busy street. It was around 3 p.m. on a busy corner. There were multiple individuals, innocent individuals that could have been at risk if defendant did have a weapon.
Accepting that show-ups are generally more inherently suggestive, the officers, what the officers said to the witness in bringing the witness to the show-up, doesn't that taint it even more?
So it becomes unduly suggestive when there becomes a substantial likelihood of misidentification. And given that statement, it did not affect the reliability of the teller's identification. He knew what this the suspect's appearance based on coming face to face with him during the crime. It was the exact appearance that was, the description was exactly correct as to the surveillance video image. And the defendant was in the same exact appearance as he was during the show up.
And the show-up happened soon after the incident, correct? And within the same geographic areas?
Correct. It was less than an hour and just 8 blocks south. So while the memory of the suspect was still fresh in the teller's mind, the teller also seemed sure of his identification. He was not given any promises or encouragements to make an identification. He had an unobstructed view of the defendant at the time he made the show up, and was only 20 feet away. So under those circumstances, the identification was reliable. There is the issue of the weight of the evidence and the sentencing, but if there are no further questions.
How did he threaten immediate use of physical force as required?
Yes, so looking at the totality of the defendant's conduct, the defendant entered the bank concealing his identity by wearing large sunglasses, a face mask.
I mean, it was COVID. I don't buy the using a mask to conceal his identity, because the teller had a mask on in the video, and other people did too.
Yes, but he had large sunglasses over his eyes covering the top half of his face. He had the hoodie over his head. He approached the bank teller and handed him silently a note demanding the immediate surrender of money. Under those circumstances, the teller already became fearful and debated whether or not he should comply, or things might escalate. And then the defendant immediately motioned his hand and put it towards his pocket, simulating possession of a weapon. And under those circumstances, that motion, the teller objectively believed that the defendant was possibly armed and was trying to compel him to produce the money. So under those circumstances, the jury was entitled to believe that defendant's actions were intended to induce the teller to comply with the note and hand over the money, making him believe that force would be used if he did not. If there are no further questions, we ask that you affirm. Thank you.
Thank you, Counsel.
First of all, the prosecution's suggestion that Mr. De Los Santos may still have had weapons is belied by the record. This was more than a routine pat-down.
Counsel, you have to concede. Context is important. He was in a bank. He passed up a note. We have People versus McDonald, which I think most of us on this panel were on, actually. And it makes it sound almost like you can come to a bank, pass a note, and make a few gestures, and that's enough to show possible immediate use of physical force upon another person.
I believe that in my reply, we explained why McDowell was distinctive. There, in 2 separate incidents, the defendant said, "You know what this is, just give me the money." And in the second statement, he said, he demanded, "Give me the money and no one would get hurt." So that is very distinguishable from our case here, where the suspect simply wrote on a deposit slip, "Give me all the money now." This could be an individual who didn't have familiarity with the banking system or had some kind of... Yes, Your
Really?
Honor. Your Honor,
You didn't have familiar with the banking system, said, "Give me all the money now." That's your argument? I mean, I don't even think that based on our case law, it is enough to walk into a bank and demand money for it to be implied that there's going to be some force to assist in taking that money.
I hear you, Your Honor. If I may, I'd like to use my remaining time to just quickly clarify the point that...
Are you agreeing with my colleague, then?
No, Your Honor, I do not. The record does not indicate that the suspect implied a threat of force. The individual, all that the record shows is that the individual wrote on a deposit slip, "Give me all the money now." That could have been someone who didn't understand how the banking system worked, who had cognitive limitations, someone who... There was just no threat here, no "or else," or "I'll hurt you." There was no instance of him placing his hand in his pocket.
What about his actions and sort of like leaning into the window and putting his hand in his pocket?
First of all, the surveillance footage did not actually depict him doing that, and from the position where the teller was sitting, it seems unlikely that the teller would have been able to see that. But in cases where the courts have found that placing one's hand in one's pocket contributes to this implied threat, there has also often been additional circumstances. For example, making it into the shape of a gun, or doing that action and making a threatening comment. There was nothing along the lines here. You know, immediately after handing the note, we see a slight gesture of the shoulder in the surveillance footage. We don't actually know what that is. To the extent that it is placing a hand in the
So
pocket.
give me all the money implies I'd like to make a withdrawal from my account.
I'm saying there are circumstances where I think it may be the case that an individual could do that who just doesn't have a full grasp of how the system works. Thank you.
Thank you, Counsel, and thank you both. Watson v. Intercounty Paving. Please.
Good afternoon, Your Honors. May it please the court, Lara Liotti on behalf of the appellant of Royal Guard Fencing. The motions for summary judgment decided by the motion court the decision was based on speculation and credibility determinations, which were improper for a court to make. If there were issues, questions of fact, they should have gone to a jury.
So, question, when you say speculation, you're not disputing the fact that there were two, I don't know if you want to call them bolts or rods, but let's call them bolts, two bolts protruding from the sidewalk, right?
There's no dispute that there were the threaded bolts out of the pavement. What is at the heart of this matter is how did they get there? How were they installed?
And do you dispute or do you believe that it's speculation that those bolts constituted a tripping hazard, given their length and their location?
We would agree that is not.
Would concede that, right?
No, I apologize. No, that there is an issue as to whether it's a tripping hazard. They were out in the open.
2 inches.
2 inches. They are out in the open. But again, I would just like to draw the court's attention back to the fact that the ultimate issue of this case is how were they coming to be out of the pavement, and who was responsible for that?
So doesn't the record indicate that RGF was the only entity that was involved with the placement of the bolts, as in making the holes and installing the bolts into the ground?
Respectfully, I don't believe the record shows that.
Is there any intervening entity anywhere in the record? Anybody who was contracted to perform that work or who took on that responsibility other than RGF?
Well, RGF did not take on with respect to these specific bolts. I believe maybe Your Honor is referring to what the motion court was looking at, is that there may have been these types of bolts used to install bike racks along this pathway that was being done.
Right, so there's a distinction between the bike racks and the fencing, is that what it was?
Yeah, it is a wooden guardrail.
The guardrail, thank you.
Yes, what is at issue is that the court looked at, and that's what we would say there's at least questions of fact, is because you have, they were relying on, number one, the testimony of the Royal Guard president, who was not on site, who was not part of the project, he's just an owner. And he said, well, we may have used these bolts in general to install bike racks, but if you refer to the record, the photographs showing the bolts, as well as the site plan that was used to implement the plan, was there were no bike racks implemented or planned for where the plaintiff
So what
fell.
about Mr. Delvecchio's testimony, the IPA superintendent, who said he observed RGF drilling the bolts into the concrete? So there you have, in order to install wooden posted rails. So is there any issue as to his testimony? Did anybody rebut that testimony? No, you weren't there, or that's not what you saw because something else happened?
Yes, Your Honor, and that again also goes to this credibility determination. The motion court did not in any way cite to the testimony of the Royal Guard foreman who was on duty for part of the time, which was Bernard McKiernan. And he explained at length how you would install.
Mr. McKiernan testified that he wasn't there for the whole job.
Yes, but he did testify that he did install.
Why is that testimony important in light of DeVecchio's direct observation that he observed the employees putting these bolts in the sidewalk?
Because the testimony is that with Mr. McKiernan's testimony, he clarified that there's no reason these bolts would have been there. They would have not resulted
That may
in.
be true, but he didn't see it, right? He wasn't there. He wasn't on site, and that goes directly against DeVecchio's observations, which says, I observed their employees actually putting these bolts in.
But Mr. McKiernan was on site. He was the job foreman. He did not, just to clarify, I mean, he was on site. He testified that he did install string line for the guardrail, and you would not use the bolts, rather that you would use weighted buckets. And that's a credibility issue.
How is it if Mr. McKiernan testified that he wasn't there for the whole job?
I apologize, Your Honor, I did not.
Sorry.
I couldn't hear you.
How is it, Mr. McKiernan testified that he wasn't there for the whole job? How does that rebut Mr. DelVecchio's testimony that he saw RGF workers installing the bolts?
Well, Mr. DelVecchio's testimony is also not specific. He's saying, okay, I saw them. He doesn't say these specific bolts. I saw them install.
And neither does the witness. Does your witness deny that RGF employees installed the bolts, as opposed to saying this is not something that we would do or something else? As I read the record, there was no direct denial.
He said he would not understand why. And also to point to Mr. Guercia's testimony, his understanding of how the bolts at issue are, how a string line is set is that it's not typically used. That's an inefficient and expensive method.
Not typically
to put all this in.
Not typically used, not that it's never done that way.
Not that it's never done, but at the very least, I would just go back to this. Mr. McKiernan's testimony at the very minimum raises a question of fact between his credibility and Mr. DelVecchio's credibility that would be for a jury and should not have been decided that Mr. DelVecchio is the more credible. If you also believe Mr. DelVecchio's testimony, you would also then have to say, well, he said that he saw them, Royal Guard, remove these bolts and fill it in with epoxy. So why are these now?
Except for these two that were left behind.
Yes, exactly. And also that goes to that.
He said would have been RGF's responsibility to remove.
They would have, but he also testified that it ultimately, Intercounty was responsible for the work that was done and the site safety. And that would include, and he acknowledges, he says, yeah, we all missed it. He's trying to put it
We
around.
have time in rebuttal as well.
Thank you, Your Honor.
Respond to that. Thank you. Please.
Good afternoon. My name is Stuart Diamond. I'm here for the plaintiff's respondents. This appeal is not about credibility. The problem with Mr. McKiernan's testimony was not that he was an incredible witness, it was that he was an unknowledgeable witness. By his own testimony, he was not a supervisor, he was just a laborer, he was not a foreman. He said himself on page 1400, I was kind of like a foreman at the beginning of the job.
He was an iron worker, yeah?
He was a journeyman iron worker. He said he was not there for the whole job. He testified that he doesn't know how the other Royal Guard workers installed these bolts and brackets. He estimated he was there for about 15 days. In their brief, they say that they were on the job for 2.5 months. He acknowledged that he wasn't there when the job was finished by Royal. He did not even know that he himself ever installed any of these bolts or brackets on this job. As counsel said a couple of minutes ago, Mr. McKiernan did not say what he did. He said, to use her words, how he would have installed the bolts. And on page 1466 to 1467, he was specifically asked, after this line of questioning about general policy based upon his experience on other jobs, are you saying that that's how you did this on this job? He said, I don't know. I don't even know if I installed any bolts on this job. And even if he had, that doesn't get us past the problem, that he left the job long before it was finished. He himself acknowledged that he doesn't know how these other employees.
So he was there 15 days and the job lasted 2.5 months. And was he there for the first 15?
He's not specific, but he was there he wasn't there at the end.
He wasn't there
He
at the end.
acknowledged.
Yes.
And on the issue about and Mr. Del Vecchio did say, this is not rebutted by any other evidence, specifically that he saw them install these bolts for these brackets.
On more than one occasion.
Yeah, and it was not the bicycle rack bolts. He said he saw them install these bolts. And what he also testified, not that he saw them remove all the bolts. He was asked, did you see them remove any bolts? And he said yes. He did not say, I saw Royal or anyone else remove all the bolts. And obviously, all the bolts weren't removed. We know that these two were still there. Thank you.
Thank you, Counsel.
Good afternoon, Your Honor. Sophia Uveda for Respondent Intercountry, or I can call it IPA if it's easier. I just want to address your question, Justice Mendez. You said, when was Mr. McKiernan on the site? And the testimony was he was there for the beginning of the project, and he testified he started the project because the actual foreman on the site, which was, I believe, Fred and Stephen, were finishing up another project. So he started at the beginning, so the first 3 weeks, and then the foreman who were supposed to run the project came in and took over. Both Mr. McKiernan and Mr. Del Vecchio explained that in the process of starting the project, Royal first started on the grassy areas because those were easier to start right away. And only after the concrete was cut out by Intercounty did they move on to the pavement or concrete areas. So because there needed to be prep work done before they could do the pavement and concrete, that was started later on in the project. And I briefly want to address the indemnity claim because the court granted indemnity to my client. There's not a lot of dispute about the actual indemnity clause. It does say for any claims arising out of the performance of the work. And as the court properly found below, that Royal was involved in putting in the bolts, it arises out of the performance of the work. Really, appellant's only contention is, no, you shouldn't find that we installed the bolts, which I think plaintiff has already addressed and the court has answered or asked those questions. And the second point that they make is, you haven't shown freedom from negligence. And
the court did not find IPA free of negligence, right? There was no finding on that.
So the court found that there were, I apologize, the court denied plaintiff's motion for summary judgment for Intercounty, finding that there was no evidence that they launched a force or instrument of harm. We did not move for dismissal of the common law claims against us, so the court didn't search the record. But in moving for summary judgment on our contractual indemnity claim, we did make a showing that we were not negligent. And the court has everything in front of it from the motion papers below saying the determination of whether Intercounty would be negligent is the same, which is Espinal launching a force or instrument of harm. The only allegations of negligence being raised by appellants is we should have inspected and caught their mistake, but under Espinal, under Mock, and under Church, it is you have to launch a force or instrument of harm, not just fail to be an instrument of good. So not catching that somebody else left in bolts is, I think, the quintessential, failing to become an instrument of good rather than launching a force or instrument of harm. And appellant doesn't really cite any case law where the failure to catch somebody else creating a dangerous condition could create a duty of care under Espinal. So unless the court has any questions for me, we will rest on our briefs.
I don't think so. Thank you, counsel.
Your Honors, to address what the plaintiff had brought up regarding, and he said it perfectly. He said, oh, well, Mr. McKiernan was only a laborer. He wasn't a supervisor. That's exactly what we're arguing. You're making a credibility determination based on, oh, well, he's a supervisor, so he must have more knowledge or experience, and he's to be believed more than Mr. McKiernan. At the very least, there are questions of fact raised by Mr. McKiernan's testimony, which were not addressed by the motion court, which need to be explored and are, should be done by a jury. I didn't get to do so on my initial argument, but just to briefly discuss what the contractual indemnification cause of action. That too, there are questions of fact as to whether this accident arose out of Royal Guard's work. Just because they installed installed the guardrails does not mean that they installed the bolts at issue. There's been no testimony that these bolts were installed at the beginning of the project, at the end of the project, in the middle, that they were done on May 31st, 2013. We do not know what part of this was actually done. There's nothing to say that these did not predate the project as a whole, perhaps from signage that was removed for the bike path. With also respect to the contractual indemnification claim and not showing negligence, I will refer the court respectfully to the Mary Acher case, MARIACHER 225 AD 3D 1288, but specifically to 1291 and 1292 pages, which says that a party's passing omission or negligence may be evidence that it's that they caused or exacerbated a condition, as long as you can tie the evidence of this condition to that negligence. Now, we would say that that's established because there's a question of how these bolts got there. Mr. Del Vecchio is so certain that they were caused by or installed by Royal Guard, but if he also acknowledges that, yep, we missed them, that exacerbated the condition and allowed it to stay. And we thank your court for your time.
Thank you, counsel. Thank all of you. Arias v. Brooks Holding. Please.
Thank you. Good afternoon, Your Honors. May it please the Court, Jonathan D. Moran for the plaintiff appellant. Your Honors, I respectfully submit that the record below demonstrates that the trial court erred in denying the plaintiff's motion for summary judgment on Labor Law 240 sub 1. The record readily demonstrates that while performing a covered activity, my client was standing on an A-frame ladder when a concussive blast that resulted from a wire.
So in your complaint, you do say, you mentioned electrocution, but I take it you're backing off from that now, right? You're not saying that he was actually touched by electrical current?
That's correct, Your Honor.
Okay.
The deposition testimony of the plaintiff is quite clear that there was an explosion caused when the wire that was being run through the wall by a colleague contacted a wire that was part of a junction box. And my client testified at deposition very specifically that the explosion occurred. He had 2 feet on a rung, a left hand on the ladder. The explosion occurred. He put both hands on the ladder, and the explosion pushed him and the ladder over. And he was questioned, did the ladder fall with you? And he said it did. And he said the ladder fell.
How is this case different from Nazario?
Nazario?
Yes.
Yes. So both Nazario and
Cataya.
I'm sorry?
Cataya and Higgins, those three.
Yes, thank you, Your Honor. All 3 cases, there was no evidence in any of those cases that the ladder there, in any of those cases, failed to remain erect and steady. And that is a crucial distinguishing factor as opposed to this case where we have unrebutted testimony that the ladder he was on fell over, which
Isn't it a fact that in those cases, the plaintiffs were thrown from the ladders and that at no time in those cases did the ladder move, but that the Court of Appeals found that there were issues of fact on proximate cause because the plaintiffs were thrown from the ladder as opposed to the ladder moving, causing the plaintiffs to fall.
I would agree with Your Honor that this evidence in those cases suggested that the plaintiff was thrown from the ladder. And I would just add to what Your Honor said, which is that not only were the plaintiffs thrown from the ladder, but the plaintiffs in all of those cases could not say, and the record in those cases did not establish, that the ladder somehow failed.
Well, what is the evidence here that the ladder failed when this plaintiff testified that he was thrown from the ladder?
Well, respectfully, Your Honor, he testified that he was pushed with the ladder and that the ladder fell over with him while he held on to it.
Well, isn't that exactly what happened in Nazario, that the ladder fell with the plaintiff?
No, Your Honor, I believe in Nazario.
Was it in Higgins that the ladder fell with the plaintiff?
There was no evidence in Nazario that the ladder fell with the plaintiff, is my understanding of that record.
Okay.
And I think that is a crucial distinguishing factor here, because the failure of the ladder to remain erect and steady and the fact that it fell with the plaintiff in this case establishes a presumption that it was inadequate, which has been unrebutted.
So just that I understand, what the plaintiff testified was that as a result of the explosion, both he and the ladder were moved.
Yes, and just it's cited page 17 of my initial papers. The question was, and what happened after the wire came in contact and you said an explosion occurred? Answer, an explosion occurred, yes. So after that, the force of the explosion pushed me and the ladder, we fell. And did you fall off the ladder, or did the ladder fall with you, or something else? Answer, it fell with me. Mm-hmm. That is the testimony.
That's unrebutted, correct?
Sorry?
That's unrebutted.
That's correct, Your Honor, unrebutted. And I would just point out that that is the crucial distinguishing factor.
One more thing.
Absolutely.
This plaintiff, he inspected the ladder before he used it, right?
Yes.
And there was nothing wrong with the ladder.
There was no evidence on this record that there was a defect with the ladder. Mm-hmm. However, this department, as well as other departments, have held that the failure of the ladder to remain erect and steady creates a presumption that it was inadequately secured, and there is no burden upon the plaintiff moving for summary judgment under Labor Law 241 to show that the ladder was somehow defective, where that presumption has been established through the movement of the safety device.
So we have here that the ladder fell with the plaintiff, who was thrown due to the explosion.
Well, he fell with the ladder, but yes, I assume one could categorize that as being thrown from the ladder. He fell with the ladder. Okay. My understanding of his testimony, I think, is pretty clear, is that he held the ladder and they both went over at the same time. So I don't know that that's necessarily...
This would be more like the Avila case, which was from 2020, where some debris caused him and the ladder to fall to the ground.
That's correct, Your Honor. Paz Avila, yes. Unless the court has any questions for me, I'll rest on my brief pending rebuttal. Thank you.
May it please the court, Eric Schlesinger, Law Offices of Golden Rothschild, Spagnola, Lundell, Boylan, and Gruba and Bell, on behalf of the respondent, Brooks Holding Corporation. What is presented to the court today is the labor law version of which came first, the chicken or the egg. Did the ladder fall with the plaintiff because the ladder failed, or did the plaintiff, because he lost his balance as a result of the electrical arc occurring directly in front of his face, pull the ladder down with him?
But I think that the difference between how you're, putting it and the cases is that regardless, the ladder fell, right? And it's not if he was thrown from the ladder because of an electrocution or an explosion. It fell with him.
Well, that's the interesting issue, and that was presented and argued in the court below. And the court below looked at that and said, a fair reading of plaintiff's deposition testimony, it could go either way. That plaintiff fell, and he pulled the ladder back with him, which means the proximate cause, was not the failure of the ladder, and that there is a question as to whether or not the ladder acted as an adequate safety device or was an inadequate safety device. The issue that the court said is there's a fair reading of plaintiff's deposition testimony that it could go either way, because I had moved for summary judgment on behalf of Brooks Holding Corporation as well, and the court denied my motion based on that very same circumstance. He said it can go either way, and it's up for the jury to determine based upon the credibility of the witness, and they're assessing his credibility and his testimony at the time of trial of what happened when that electrical arc occurred. And as much as plaintiff wants to call this as an explosion, which he said in his deposition testimony, and which counsel here now qualified as a concussive blast, this was not an explosion. It was an electrical arc. A piece of metal came in contact with an open electrical circuit, and that's what everybody has testified to in this case. We're not talking about
Are you making that distinction because an arc does not have any kind of force that arises from it, like some kind of movement?
It could, but the plaintiff didn't talk about any force. What he talked about is this occurred in front of his face. He moved backwards.
So we know that the electrician who, or what, let me not say we know. The record indicates that the electrician who was assigned to do this work left the plaintiff and someone else to work on it, to work with wiring specifically, and the electrician just left. Is there any indication that the electrician gave instructions to the plaintiff as to how to use the ladder, in performing this work?
The electrician was plaintiff's co-employee. He was employed by New York Interior Construction, who is also plaintiff's employer. And plaintiff testified at his deposition that the electrician opened up the panel. Plaintiff had no training with respect to electricity, and that he was simply going to pull the wires through, and that the electrician had left. And that the co-employee and the plaintiff had an agreement that the plaintiff would call the co-employee on his cell phone and say, run the wire through, I'm ready. That didn't happen. Brooks Holding Corporation wasn't in charge of this site. Yes, we are the statutory owner for purposes of ownership of the building because it's a co-op, but they weren't doing this project. It wasn't the Brooks Holding Corp project. It was a project done pursuant to an alteration agreement hired by the third-party defendant Lamps. Brooks Holding Corp didn't even hire this contractor. They just knew that they were on site in that aspect. They had no supervisory control.
So in denying the motion, the court referenced Kateya and Nazario.
Correct.
Okay, how is this case different from Kateya and Nazario?
It's not. It's not at all.
And how is it similar to those cases?
It's similar to those cases because in both Kateya and Nazaria, an electrical issue occurred which caused the plaintiffs in both of those cases to lose balance and come off a ladder. And in both of those cases, there was no defect with the ladder. And in this case,
Right, but that's
there was no
different than
defect
what
with the
happened
ladder.
here. Because in those cases, they fell from the ladder. In this particular case, the ladder fell with him on it.
Well, but the ultimate question, which goes back to my original point, and I understand I'm out of time if the court would allow me just to answer the question.
Bring it to a chicken and egg conclusion.
Is simply this, that there's a fair reading of both ways on plaintiff's deposition testimony of whether or not when plaintiff moved backwards, because he placed both hands on the ladder, did he bring the ladder down with him? Or did the arc or concussive blast, as plaintiff counsel likes to describe it, cause the ladder to move? And you don't have those facts in these cases, and that's why the court found below that there was a question of fact and summary judgment was inappropriate.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. My name is Lana Klein. My office represents the third-party defendants, respondents David Lamb and Jessica Lamb. We take the same position as Brooks Holding Corp. We believe that the court made the right decision in denying plaintiff's 240 motion, even though we're the third-party defendant. Any decision as to the labor law will eventually trickle down to us. I believe that the court properly found that there's a question of fact as to whether if the ladder had been placed somewhere else, whether that could have changed the outcome, whether a different safety device would have been appropriate. We don't believe that the ladder failed in any way. The case law that plaintiff cites, in each of the cases that he cites, the ladder moved in some way before plaintiff fell off the ladder. That did not happen here. The Nazario case is actually directly on point because the Nazario plaintiff and the ladder both fell, and the court still found a question of fact in that case. I have nothing further. Thank you.
Thank you, counsel.
Thank you, Your Honors. I'll try to be as brief as possible. First, I would like to point out that whether one terms it as an explosion, a concussive blast, or an arc, the testimony on this record is that it was an explosion and that explosion is what pushed the ladder and the plaintiff over onto the floor. However, even if one were to assume...
Isn't that point what separates, what differentiates this case from the other two Court of Appeal cases?
Absolutely.
Where here, there's specific testimony that whatever happened, whatever you want to call it, blast, explosion, it caused the ladder to move.
Absolutely, Your Honor.
There's nothing to contest that.
Absolutely. There's nothing to contest that the ladder fell over. That creates a presumption that it was inadequate. That is a quintessential violation of the labor law statute. There's been not one shred of testimony or evidence produced on this record to suggest otherwise. And I also just point out to my colleague's point about whether he jerked in some way that made the ladder come with him. There are cases from this department that also hold that where that jerking movement causes the ladder to fall over, it's still a labor law 240 sub 1 violation. That's Del Rosario, where a live electrical wire touched the plaintiff's face and he jerked backwards and that pulled the ladder over. 240 sub 1 was granted to the plaintiff in that case in this department. I'd put in the Daniello case, which is he's working on a drop ceiling above him. A part of the drop ceiling falls. It startles the plaintiff. He jerks backward. The ladder falls with him. 240 sub 1 was granted to the plaintiff in that case. So I don't in any way...
In any of these cases, was there an electrical arc?
I couldn't find
explosion?
I couldn't find anything of similar nature where there was an explosion such as this, which it pushed it. But I think the point is that the ladder failed to remain erect and steady, which is, at the end of the day, at the crux of a 240 sub 1 case. That didn't happen here. The ladder fell over with the plaintiff. That's unrebutted. It creates a presumption that it was inadequate.
Thank you, Counsel.
Thank you, Your
Thank you
Honors.
all. And last but not least, PennyMac Loan Services. Please.
Good afternoon, Your Honor. And may it please the court, Diana Ang of Blank Rome on behalf of plaintiff respondent PennyMac Loan Services, LLC. The lower court correctly denied the appellant's motion to...
Could you please lower the microphone? Thank you.
Apologies. The lower court correctly denied appellant's motion to vacate his default and to vacate the judgment of foreclosure and sale based on the alleged failure to serve process under CPLR 5015A4 and also CPLR 5015A1.
So, counsel, can I direct your attention to Exhibit K, which is the death certificate of Andres Valdez?
Yes.
The death certificate indicates that Mr. Valdez was born on November 30th, 2012, and died on May 14th, 2012. The death certificate was certified on May 17th, 2012. In other words, the death certificate indicates that Mr. Valdez died before his death. And most interestingly, the certificate of translation says that he was born in 1949, which absolutely is not a translation of the death certificate. So under these circumstances where the defendant says there's no way that my father could have been served because he was dead. What do we make of that?
Well, I'm glad you asked that question, Your Honor, because I was headed there as one of my points. The plaintiff, the appellant repeatedly harps on the death certificate and says that the process server served process on his dead father, but directing the court to the record at 105, the affidavit of service says that a family member was served. It never says it's his father. We've all seen plenty of affidavits of service. Sometimes it says mother, father, sister, brother, spouse, husband, wife. This says a family member. And despite appellant's repeated arguments, it doesn't say that the person served was his father. And he also doesn't say ever that no person fitting the physical description in the affidavit of service was served, nor do they ever state that no person of suitable age and discretion was served. So those are the requirements and also the documentation required to rebut the process server's affidavit of service. And here, the appellant has failed to meet that burden. I mean, going to the other issue, which was the stop work order at the property, I'm sure the panel.
Well, that was really interesting because, as we all know, a stop work order is not the equivalent of a vacate order.
Correct.
So anybody could be present at the premises and be properly served.
And that was the point I was going to make. A stop work order is not stop remediation. I mean, the property was, the construction was completed the month after process was served at this property. And again, the affidavit of service reflects that a person of suitable age and discretion was served at the property. And again, nothing in the record shows that no person of suitable age and discretion was at the property. Nothing rebuts the physical descriptions of the process server's affidavit. So all of the evidence that the appellant submitted was conclusory. There is nothing that meets the standard that this court has set to rebut the process server's affidavit.
Thank you, counsel, and thank you for your patience.